I'm sorry. The Vice Chancellor, Chief Justice Maitre Butare Emmanuel and Dr. Prosper Maguchu will talk about the visibility of the School of Law in terms of infrastructure. Yeah, I think that's the place where this picture will come back when we are talking about the infrastructure of the school. Then we'll follow a Q&A session. After that, we will launch officially the UR Alumni Association School of Law chapter. And this will be done by Dr. Nezirgayo Faustin, Chief Justice, and who is also the chairperson of the University of Rwanda Alumni Association. And with that, we'll have closing remarks by the guest of honor. And of course, we'll have a networking cocktail, not far from this room. So, ladies and gentlemen, this is the exciting program that we are going to go through this afternoon. Allow me now to welcome Mr. Dennis to give us his welcome speech.
Honorable Chief Justice of the Republic of Rwanda, Dr. Nezirgayo Faustin, Honorable Minister of Justice, Dr. Ugirashebuja Emmanuel, Honorable Prosecutor General of the Republic of Rwanda, Mr. Havugiyaremye Aimable, representatives of development partners that may be here present, justices, heads of institutions here present, our friends from the Netherlands, Professor Marcel Bruce and Dr. Maguchu Prosper from Groningen University and VU Amsterdam, respectively. My fellow academics, members of the UR Alumni Association School of Law chapter that we are going to launch today, distinguished guests, ladies and gentlemen, all protocols observed. Today, on behalf of the School of Law and on my own behalf, it is my pleasure to welcome you all at this legal interface workshop in 2022. The School of Law has held other 4 legal interface workshops before. The last one, in fact, took place on the 23rd May 2019 and was very special. We had about 40 deans and senior judges that came from African states and beyond to participate in the workshop. Since then, however, we did not get another chance to convene this kind of workshop, mainly because of COVID-19. This year, we have another legal interface workshop that is also very unique to us, with the theme, Rethinking Collective Responsibility in Legal Education. We will have researchers to present their findings on 2 topics, and we have different panels to discuss this theme, and the outcome of this workshop will help us at University of Rwanda School of Law and the whole legal education in Rwanda to understand how best we can collectively upgrade legal education. As you may know, the School of Law is hosting you now. This is a school that was established in 1973 as part of the National University of Rwanda. Today we are part of University of Rwanda since 2013 under the College of Arts and Social Sciences. The School of Law, we are happy to mention that we have over 500 students in total in our main campus. Now to respond to the question, in Huye, Southern Province, but we have another campus here in Kigali of LLM students, and soon we will be having PhD students as we are currently finalizing enrollment procedures. Based on the collaboration we have with the National Police, we also teach other students at the National Police College situated in Musanze district. I'm happy to note that today the School of Law will officially launch the University of Rwanda Alumni Association School of Law chapter. Dear participants, mark that our chief guest, the Chief Justice of the Republic of Rwanda, Dr. Nteziryayo Faustin, is the chairperson of University of Rwanda Alumni Association. Therefore, our chapter has a firm foundation. Thank you for accepting our invitation and to be with us here in this discussion. We particularly need to understand the contribution of our alumni in upgrading legal education at UR School of Law, but in the whole country in general. Dear Chief Justice, ladies and gentlemen, the School of Law has advanced in collaboration, and we are happy to note that with the collaboration, we can reach on the goals aiming at advancing legal education in Rwanda. We are therefore still thirsty for more close collaboration in Rwanda and beyond. We believe that through collaboration, legal education can be uplifted. This workshop was organized in collaboration with VU Amsterdam and the Institute of Legal Practice and Development, ILPD, situated in Nyanza. We are very thankful for this collaboration that is supported by NUFIC, the Netherlands, under Just Project, which Just Project in full, it's a long, Justice for All through University and Professional Sustainable Service Delivery, Teaching and Training. The project has institutions from the Netherlands that are part of it, that is VU Amsterdam, and Silk, Center for International Legal Cooperation. And in Rwanda, we have the Institute of Legal Practice and Development, ILPD, and the University of Rwanda School of Law. The project's objectives is to promote just, peaceful, and inclusive societies and achieving legitimate sustainability and stability. This is done through strengthening of capacity, knowledge, and equality of individuals as well as organizations in the field of higher education in Rwanda. With the support of the project, Honorable Chief Justice, ladies and gentlemen, great achievements have been recorded in quality education, quality research, access to justice, and institutional collaboration as the main pillars of this project. In education, allow me to mention that a series of trainings have happened, training online, curriculum review that is being finalized, training on competence-based education and training, among many others. In quality research, the School of Law and the ILPD academic staff have been trained on proposal writing, trained on supervision of academic papers, trained on research and publication, to mention but a few. Important to mention too, under these pillars, ILPD and the School of Law of University of Rwanda have 2 PhD students at VU Amsterdam that are being sponsored under JUST project and helped by VU Amsterdam law professors on their doctoral studies. Concerning access to justice, the School of Law with its Center for Legal Aid and Mediation and the ILPD have been trained on mediation and referral to mediation. Through JUST project, the beneficiaries of mediation training have been extended, whereby some members of the judiciary, members from Ministry of Justice, and members of court annexed mediators were also trained under this project. This project has also supported institutional collaboration. University of Rwanda has signed the MOUs with other institutions. For example, the one that was signed between University of Rwanda, the School of Law, and Groningen University in the Netherlands, and another one that is being finalized with VU Amsterdam. Let me also mention that it is under this pillar of institutional development that this workshop was also supported. Dear Chief Justice, our guest of honor, ladies and gentlemen, University of Rwanda School of Law has also a firm collaboration with stakeholders in the country. Since 2019, some MOUs were signed between University of Rwanda School of Law and other institutions in the country with, for example, Rwanda Investigations Bureau, ILPD, and the Rwanda Law Reform Commission. There is a close collaboration between our institution, the School of Law of University of Rwanda, and these institutions. As I have mentioned, the School of Law and the ILPD are closely working together to implement JUST project activities. We are also jointly running a law journal, Rwanda Law Journal, and this will be expounded by my colleagues Didas and Etienne. Also, our academic staff have been assisting in the trainings organized by ILPD, and this is to mention but a few. With RIB, Since last year, 2021, our academic staff are assisting in training RIB officials. So far, the first intake graduated, and we are currently assisting in the second intake as I speak. With those few remarks and the imagery of the school you love, the school you are longing to serve as alumni, as collaborators, stakeholders, I would, on behalf of the School of Law, thank you for coming, thank you for participating, and I wish our participation in our discussions here is going to be fruitful for the good of legal education in Rwanda at large. Thank you so much.
Thank you so much, Dr. Dennis. Actually, I would have expected a louder round of applause. Because when I was listening to him, I heard the impression of listening or hearing the curriculum vitae of the School of Law since its inception in 1973 up to date. And when I carefully remember what I just said, I find that actually it is very impressive. A lot of things have happened, and a lot is still happening. With this, I would like to welcome Dr. Alphonse Mulefu, acting principal of the College of Arts and Social Sciences, to also give us his remarks. Welcome, sir.
Honorable Chief Justice, our guest of honor, Honorable Minister of Justice and Attorney General, Prosecutor General, CEOs present, heads of institutions, justices, ladies and gentlemen. It is a great privilege to welcome you all to this interface workshop for the School of Law. I wanted to particularly thank the organizers, the School of Law, and its partners, the Institute of Legal Practice and Development, and the Free University of Amsterdam for organizing this event. Dear guests and participants, those participating here and those participating online, thank you very much for accepting our invitation. Before I start my remarks, I want to note that the Vice Chancellor was in a meeting and is being delayed. As soon as he gets here, before I conclude my remarks, I will give him the floor to welcome the guest of honor. And if he's not yet here, after getting the permission from the organizers, I will humbly invite our guest of honor to give the official opening remarks. Since the Vice Chancellor is going to be part of the session that we will have later, I think it would be not a big offense for him to make extra comments during that session, in case he isn't yet here. So, Honorable Guest of Honor, Chief Justice, the members of the Bar Association have different forums and events that bring them together. Those in prosecution have their meetings. The judges is the same, and other professional bodies in the legal practice. And us in academia also have our own ways of meeting, conferences and seminars. But each legal practice in their professional groupings. The main function of forums that bring people in the same profession together is mainly to promote high ethical and professional standards within that particular profession. The idea of having the interface, when it was being thought about some few years ago, and I can remember one or two individuals also here present, was intended to create a gathering where all people in the different specializations and categories of legal practice would meet and exchange on how to improve the legal environment in Rwanda and share ideas in an open and intellectual manner on topical legal questions of national interest. I hope that we will be able to realize this vision, because whether you are a lawyer, a prosecutor, a lecturer, a judge, a legal officer, a court bailiff, a company secretary, or in any other category of legal practice, we all wish to see positive progress and development of our legal environment generally. We cannot have good lawyers without good judges or good teachers. We all need to grow and develop together. For members of the School of Law alumni to be inaugurated today, I am sure you have good memories of the time at the University of Rwanda or at the National University of Rwanda as it was then. Like the role of other alumni associations, we hope that you will be our royal strong supporters, be our good ambassadors and role models for our students, but also provide practical and material support to improve the legal education in Rwanda. In your capacities, if a student comes for an internship, for example, do not give them those tasks of photocopying and messenger services only. Offer them real training and guidance, but we also know that you have expertise in different fields where you belong. We will be inviting you to give guest lectures. But some are also capable of offering more than that through your companies and firms. Therefore, let us, as today's theme states, rethink of our collective responsibility in legal education. I had not planned to make a very long speech, so on this note, I would wish to invite our guest of honor, the Chief Justice, to give his official opening remarks. The guest of honor, sir.
Let me start. I don't want to be long in the protocol. So because we are in a university setting, so you allow me not to go into protocol. Let me say, distinguished participants. So distinguished participants, I would like to thank the organizer of this workshop for the invitation extended to me. It is really a pleasure to be with you this afternoon in my capacity as the head of the judiciary. But most importantly, I think, and given the theme of this afternoon workshop, as an alumni of the University of Rwanda and of the then Faculté de Droit, now the School of Law. I graduated in 1986, so it is really a pleasure to come back here when we are talking about how we can improve legal education. From the outset, let me state that the judiciary of Rwanda is very much interested in legal education. In fact, we think that discussing legal education is especially pertinent for an effective and efficient justice dispensation system, because what education law students receive will also deeply shape how justice will be dispensed in our country in the years to come. Distinguished participants, it is in this regard that the judiciary is very supportive of a legal education system whose key goals at the high level are to champion justice and to uphold the rule of law. But to advance those broader objectives, the legal education must equip graduates with requisite knowledge, skills, and values to serve as competent and ethical legal professionals capable of meeting the challenges of the legal profession. And I am happy that the motto of the School of Law is stated as aiming at excellence in legal education. I may say that this aspirational and visionary thinking, that is the thinking of having legal education that is to the meeting the challenge of the legal profession in order to fulfill for legal professionals to fulfill their legal obligation. This aspirational and visionary thinking is, however, challenged when one considers the state of the legal education system in this country. In fact, the proliferation of law schools in different universities and deficiencies in the legal education have raised alarms about quality control at these institutions and the ability of the new generation of legal professionals, be it lawyers, being prosecutors, being judges, etc., to fulfill their professional obligations. I'm happy to recognize the Minister of Justice and Attorney General with whom we have discussed this matter of really the concern about the control of the quality of legal education that is provided in various private universities, for example, and the quality of graduates we are getting and the quality of professionals we are getting, legal professionals we are having on our marketplace. The poor performance is manifested through the lack of core professional competencies such as critical thinking, legal knowledge, practical skills, and ethics. I'm sorry that I will not be as enthusiastic as the dean of school of the law school was, but that is the reality that we have to point out. We have to recognize that we have really many challenges as far as the quality of legal professionals we are having at the marketplace is concerned. Thus, there is a need for a comprehensive legal education system reform to set up a well-designed legal curriculum that promotes substantive knowledge, practical skills, and professional ethics in the training of legal professionals, as well as an institutional oversight and coordination of legal education. I'd like to hereby commend efforts that are undertaken by the leadership of the University of Rwanda and the University of Rwanda personnel, being academic personnel, but also administrative personnel, to level up the quality of education and to foster a culture of excellence within the institution. This could be boosted if a culture of meritocracy, that is, a world-class culture valuing the recruitment and promotion of on merits, was instilled in our workplace in such way that this could be an incentive for learners to perform better in order to be more competitive. We have seen that when we level up the quality of education, we will likely to have people that will be likely be qualified at the workplace. And of course, as far as my area of interest is concerned, that is the justice sector, will be able to have, judicial personnel at every level that are qualified. So the judiciary of Rwanda will continue to work hand in hand with other stakeholders in order to improve the quality of legal education, in order to strengthen the capacity of legal profession, the judiciary included, to fulfill our overarching mandate to uphold the rule of law. So I would like to commend all stakeholders that are helping really our institutions, being the University of Rwanda, but also other high learning institutions providing legal education in order to fulfill their mandate, being the stakeholders in the country, but also our counterparts in a foreign country like the Netherlands. So it is on this note that I wish all of us a fruitful deliberations, and I thank you for your kind attention.
Thank you very much, Honorable Chief Justice, for these powerful opening remarks. I don't think that I'm qualified enough to summarize this very clear and thoughtful speech. So it is planned that after the Chief Justice opening remarks, we are supposed to have a group photo. I would like to call the organizers, the media group. And the group photo will be taken from the room, so we don't go very far from our seat. Can you bring 7 or 8 chairs here to make the first rank? It is now out? I need someone to show guests the way for the group photo. Honorable Chief Justice, Honorable Minister, dear Prosecutor General and all guests, can we go outside for the group photo, please? Thank you all for having come very quickly back to the room. Now we are going to our research sharing session, and allow me to invite here at the front Dr. Abimana P, Dr. Sezirahiga Eve, Dr. Kayihura Didas, and
Recording in progress.
Dr. Ruebana Etienne. One, two, three. So this session was supposed to last around a couple of minutes, but we'll try to catch up time. So our first two speakers, instead of 20 minutes that each of you had, we'll try to reduce it to 15. Then the discussant also will have some reduced minutes that I'll announce. So now we'll start with Dr. P. I'm very happy to introduce our very last born doctor at the School of Law, that Dr. P. Abimana, and I guess this is his first kind of public presentation after his graduation. So we should be all very careful to listen to what he has found. And I guess, recent born, not the last born, okay, because there are others coming. All right, our most recent. So he'll talk about harmful tax competition in the East African community. And I guess this is part of his PhD research findings. Dr. Pai, you have the floor.
Honorable Chief Justice, Honorable Minister of Justice and Attorney General, Honorable Prosecutor General, and the Honorable Vice Chancellor, the Principal, Dean, Ladies and gentlemen, good afternoon. It is my pleasure to be in front of you presenting the results of my PhD research. As the moderator said, I'm the recent PhD in the School of Law of the University of Rwanda, but not the last. And as he noted out, this is my second public presentation of my PhD. Some 2 weeks ago, I did a similar presentation to Heineken, which has been very instrumental in terms of financial support of my PhD. So my research had title of harm of tax competition in the East African community. The case of Rwanda with reference to EU and the OECD approaches. The starting point for my research was that this concept of tax competition, it is a concept which is very topical, but again, which is very controversial because scholars, they have different ideas vis-a-vis tax competition. And it is against that controversy that several international initiatives that have been undertaken to find ways of regulating harmful tax competition. We have cases of European unions which have some regulations of tax competition, and the OECD, that is Organization for Economic Cooperation and Development. So at the time of starting my research, the need was to have some research which talks about tax competition in the Rwandan aspect, because in Rwanda there are very few researches about tax competition, and it is the same situation like in the East African community. So the starting point from a legal perspective for my PhD was the legal theory of state sovereignty, which is a theory which is provided for by the UN Charter and other international conventions, from which we have a theory of state tax sovereignty, according to which every state has the freedom to design the tax system that fits with its national needs. And this freedom, it goes very far to justify the state's provision of investment-friendly environment, which means that the states are free to compete in terms of tax. How do they do it? They try to set up some favorable tax measures that are able to make an attraction of foreign investors. To do it, the main target is to attract foreign capital, but again, the second target is to protect their domestic tax base. At this point, the tax competition is not a problem. The problem comes when the tax competition shifts to a harmful tax competition. How is it done? It is done when the states go beyond building a competitive tax system, which consists in the lowering of the general tax burden for general taxpayers, to set up the tax systems that shall be eroding the tax bases of other states. That is when the tax competition shifts from tax competition or a mere tax competition to becoming a harmful tax competition. So when it becomes harmful tax competition, there are some consequences. Consequence number one is that there is a spillover of the policies of other states. How is it done? At this situation, a state's tax policy, it has consequences to the tax policies of other states. That is consequence number one. Consequence number two, there is an erosion of tax revenues. And in number three, which is a consequence of the second consequence, it is a fiscal degradation where the states become unable to collect enough tax revenues, and therefore the overall consequence is that the states becomes poor and fail to provide the basic needs to their citizens. So that is the background of harm of tax competition. And as I mentioned earlier, there are several initiatives that have been undertaken to fight against harm of tax competition. But most of those initiatives, they have been undertaken by developed countries. when you look at the developing countries, there are very few or almost to none responses. So it is the same situation in East Africa. That is why I concentrated my research in East Africa, where there is a very low engagement of East Africa partner states in fighting against some of tax competition, which can be taken either as a way for EAC partner states to continue engaging in harm of tax competition, or as a consequence of low technical capacity of EAC partner states in terms of tax competition. But for me, whatever the case, there was a need to conduct a research on this topic. So that was the background of East Africa in general. And when it comes to Rwanda in particular, since 1994, Rwanda has taken several measures to improve its tax competitiveness, including the income tax law, which has been amended several times to make sure that investors are in good positions. We also have investment law, which has been amended still several times to improve the situation of investment in Rwanda. But when it comes to tax competition specifically, it is an area which has received very little attention in Rwanda. And this is evidenced by the fact that there are very few legal literature on that topic of tax competition. But also besides that, you have some reports from NGOs, non-government organizations, which have been mentioning that Rwanda is engaged in tax competition. But the problem with such reports is that they have never made a distinction between tax competition and harmful tax competition. So that is why I focused my research on Rwanda, but also in the context of EAC, because tax competition, it is a topic that always is studied in the context of a regional or international level. So a question may be to ask why did I choose the EAC? Because Rwanda is a member of several regional integrations. So I chose an EAC because according to the EAC treaty and other legal instruments of EAC, EAC law, it is supreme to the laws of Rwanda. That is one of the reasons that pushed me to choose EAC. But also the East African community, it is one of the oldest regional integrations in Africa, and it is the most advanced if you consider that so far EAC is at the stage of common market. The problem I had is that regardless those reasons that pushed me to choose EAC, there is no distinction between economic perspectives of tax competition versus legal perspectives of tax competition in the EAC. So therefore, I found that EAC law was not enough, and thank you. And that pushed me to look at other laws which are somehow advanced. That is why I extensively referred to EU law and to the OECD legal instruments. Why? Because the EU law on tax competition, it has somehow a global application, because there are several reviews which are done by the Code of Conduct of the European Union, which concerns all the states all over the world. The same for the OECD in the matters of international tax law. OECD has a very big impact in the design and implementation of international tax law. So that is why I have chosen EAC, EU, and the OECD. My research problem was to examine the situation of Rwanda in terms of tax competition, so that I could determine whether Rwanda is engaged in harmful tax competition or not. That was my general research problem. And I had 4 research questions. The research question number 1 was to assess the current situation of the favorable tax measures in Rwanda. The second research question was to look at what conventional benchmarks can be used to identify the harmful tax practice in Rwanda. And the third research question was to evaluate the identified favorable research questions in question 1 using the benchmarks of the question 2. Then the last research question was to design some proposals that can contribute to building a tax system of Rwanda which is free from harmful tax competition. And my general objective was to determine whether the Rwandan tax laws are within the parameters of internationally accepted tax competition. Because of the sake of time, I'm trying to go as quick as possible. For the scope, my jurisdiction of study was Rwanda, but also as I mentioned earlier, I had to look at the ESC law and EU law and OECD. I can skip the research output. Maybe I can talk of the societal relevance and the scientific relevance. I believe that with my research results, at a national level, my research can have an influence on policymakers. Like for people from Ecofin and the Rwanda Revenue Authority, I believe they can use the results of my research and have an influence on the way tax policies are designed or on the way tax laws are implemented. At regional level and international level, I believe that people from other jurisdictions in a similar situation like Rwanda, they can take advantage of my research to design their tax policies. And scientifically, I believe that researchers, students, academics, they can also use my research results to develop their research as well. And I believe that my research has contributed to the board of knowledge in terms of tax competition internationally. So for the methodology, my research was qualitative, and I collected the data mainly as desk research, and I used a doctrinal approach and a comparative research complements. And the materials that I mainly used are the ESC treaty, the ESC draft code of conduct against some of tax competition, the EU code of conduct on business taxation, the OECD report on harm of tax competition, the OECD progress reports, and the assessment reports of the EU code of conduct group, and the Rwandan income tax law of 2018, and the Rwandan investment law of 2021. My thesis had 8 chapters. Chapter 1 was on general introduction. Chapter 2 was on the general panorama of tax competition. In chapter 3, I did an overview of the favorable tax measures under Rwandan law. In chapter 4, I had a focus on the EU and the OECD approaches against harm of tax competition. In chapter 5, I shifted the focus to the ESC. Then in chapter 5, I did an evaluation of the Rwandan favorable tax measures. Then on chapter 7, I did a design of the measures of the solutions that can contribute to building a Rwandan tax systems which is not harmful. Then chapter 8 was about the conclusion. My key findings are as follow. For the research question number 1, it was to assess the current situation of favorable tax measures. I first of all determined the benchmarks that may be used to qualify a tax measure as a favorable tax measure, and I defined a favorable tax measure as a measure that derogates from the generally applicable tax system by providing a lower level of taxation. And this measure, to be considered as favorable, it must have a significant impact or a potential impact on the location of the business. And this measure must be potentially harmful but not yet confirmed harmful. So using these benchmarks, I found that under Rwandan law, there are some measures which qualify as favorable tax measures, and these are the preferential tax rates, the tax holidays, the tax exemptions, the profit tax discounts, the tax rulings, the advance pricing agreements, and the tax settlements. Those were the findings for the question number 1. For the question number 2, which was about the convention benchmarks that can be used to identify the Rwandan harmful tax competition practices. I found that ideally I would be using the ESC benchmarks, but because those ESC benchmarks do not exist, I was obliged to look at the EU and the OECD benchmarks, but also I had a look at the ESC draft code of conduct. Therefore, I determined the 5 benchmarks that can be used to evaluate the Rwandan regime. Benchmark number 1 was to a lower level of taxation, which is considered as a gateway criterion, which means if a measure is not providing a lower level of taxation, there is no need to evaluate the measure for other criteria. Benchmark number 2, it is ring fencing. Number 3, it is a lack of economic substantial requirement. Benchmark number 4, it is a lack of transparency. Number 5, it is a lack of exchange of information. For the research question in number 3, where I had to assess the Rwandan favorable tax measures to determine whether they are harmful or not, I found that 2 favorable tax measures are prima facie harmful. That is a 3% preferential tax rate and a preferential tax rate to export investments. 6 measures are potentially harmful, but are not harmful. Those are the tax holidays of 5 years and 7 years, exemptions to agricultural activities, and exemption to Agaciro Development Fund and the 2BDF, the profit tax discount. And I also find that 3 measures are not harmful, but they contain a harmful aspect. That is 0% preferential tax rate, 15% preferential tax rate, and the tax rulings. And then I failed to assess other 2 measures because I failed to find sufficient information. The last research question was about the proposals that can be designed to protect Rwanda from harmful tax competition. So I made some proposals that can be implemented at the Rwandan level, others which can be implemented at the ESC level, and finally I also drafted a model of a code of conduct that can be used by the East African community. Finally, I made some recommendations to the government of Rwanda and to the ESC. Regarding the government of Rwanda, I made several recommendations, but basically, for the measures that I found to be harmful or to contain a harmful aspect, I made the recommendations on how to take rid of the identified harmful aspect. I also made a recommendation to the East African community, and I clustered those recommendations in 3. 1 is to finalize the ESC draft code of conduct against harmful tax competition and adopt it. Number 2 is to learn from the best practices of the EU and the OECD. Then number 3 is to improve an understanding of tax competition in East Africa. That is where I call more research to be done regarding harmful tax competition in the East Africa. To close, I want to emphasize 2 points. Point number 1 is that the trigger point for my research was about some reports from ESC that were mentioning that Rwanda is engaged in harmful tax competition. My conclusion on that, I say that Rwanda is sovereignly engaged in tax competition like any other state, but not in harmful tax competition. Number 2 was in relation to my research problem, which was about determining whether the Rwandan practices are within the internationally accepted principles of tax competition. And my conclusion to say that as long as there are no pseudo-binding standards that directly apply to Rwanda with respect to tax competition, it is very difficult to say that Rwanda is engaged in harmful tax competition, unless if it is done for academic or scientific purpose. Thank you so much. That is in brief what I did for the past 6 years. Thank you for your attention. I can hand over the mic to the MC.
Thank you very much. Congratulations, DRP. I can understand how frustrating it can be to have only 15 minutes to present a 6-year research. But anyway, Mr. P will tell us, Dr. P will tell us where we can find his book so that those of us who would like to read to know more, we can have access to this very interesting information. So now I would like to invite Dr. Sezirahiga Eve, who will also present his PhD research findings. The title is The Right of Victims of International Crimes to Reparations in the Aftermath of the 1994 Genocide against the Tutsi in the Rwanda. You have the floor, Doctor.
Thank you, MC. Honorable Chief Justice, Honorable Minister of Justice and Attorney General, Honorable Prosecutor General, Honorable Vice Chancellor, Honorable Heads of Institutions present here, fellow colleagues, ladies and gentlemen, all protocols observed. It is my pleasure today to present my PhD findings in the presence of my academic parents and mentors. Your kid is growing, and you should be proud of your contribution. Last year in June, I presented my thesis at the University of Groningen, Netherlands, under the supervision of Professor Caroline and Professor Alette Smeller. My title of the research is The Rights of the Victims of International Crimes to Reparation in the Aftermath of the 1994 Genocide against the Tutsi in Rwanda. The idea to work on this topic came from what I was seeing in the news, reading the news, or hearing from the people that the government of Rwanda is not doing well in terms of reparations due to the victims of the genocide. Then I was interested to see whether that is the case. And my research question, let's skip this the outlines for the sake of time. My research question is this one. I had main question of my studies: to what extent has the right to reparation of the victims of 1994 Rwandan genocide against the Tutsi been materialized? This is the main question. And to answer this question, I had also other 4 questions. To what extent do victims of gross violation of human rights have a right to reparation? Then before assessing whether the government of Rwanda complied with the rights to reparation, I had first of all to know and to establish whether victims have rights to reparation. The second question is now, how did the Rwandan government address the harm caused to the victim of the genocide of Rwanda, the measures put in place? The third question was, to what extent have the victims of the genocide against the Tutsi been given access to court to claim reparation for the harm they suffered? The last question was, is the assistance provided by the Rwandan government through FARGE a form of reparation to victims of genocide? Then, by answering these 4 questions, the aim was to answer the main question. The research objectives: the aim of this study was to assess the reparation mechanisms which have been made available to the victims of genocide against the Tutsi in line of the meaning, nature, scope, content, and the effect of the rights to effective remedies and reparations in international law. Meaning that my task was just to assess what the government of Rwanda did compared to what is required internationally, international law, in terms of reparation. That was the aim. The methodology to meet the objective of my research, I used 2 methods. I first of all I used a combination of legal dogmatic and empirical research methods. And in a legal dogmatic, we just analyzed the different documents, report, laws, case laws, and just to establish the existence or to know to what extent victims of mass violation of human rights have rights to reparation. I use primary source, as you can see, and emphasis was put to the instruments that have force of law in Rwanda, being international instruments, regional instruments having force of law in Rwanda, meaning those ratified by Rwanda. These are some of the instruments that I used. And all these instruments, being ICCPR or being all these instruments I mentioned here and others, they all provide a right to reparation to the victim. But they do not practically explain what the government should do practically. They just create an obligation for the government to repair the harm suffered by the victims. But these instruments and many others do not explicitly, practically explain what the government should do in order to meet its obligation to reparation. That's the reason why I also considered this UN basic principle and the guardian on the rights to reparation, because this is, I can say, the only instrument that provides the modalities of enforcing the rights to reparation. And I considered this as a benchmark, this UN, or as a yardstick in the evaluation of what the government of Rwanda did in terms of reparation. This is the side of the legal dogmatic. I also analyzed the secondary source to also make sure that I understand, or we understand, what is meant by the rights to reparation. Because when I started my research, I was thinking that the right to reparation was just to give financial, is in terms of finances, paying money. But I was surprised to find that it's more than that. In addition to the legal dogmatic, I also used the empirical research in the form of interviews with genocide survivors, and I had the opportunity also to have an interview with the Minister of Justice, meaning that on one side, in my research, you will find the position or the perception of the victims, but also the position of the government in terms of the reparation. This is to allow a clear insight into how victims perceive the reparations mechanism or measures put in place by the government of Rwanda. This is the methodological approach. I had what I call an article framework for my research. I prefer this mode, or what I call more Tara mode, developed by Stefan, and I was privileged to have him in my assessing committee, together with Marcel Brice, who is here present. And by using this is because it is the only mode that allowed me to just have a certain form of presentation of my findings. According to him, or it is also called 4 bleeding blocks, according to him, all governments after mass violations face these key challenges. It's about truth, accountability, reparation is the third, and promotion of reconciliation. Meaning that my presentation, even if when you look through my chapters, I present my findings in terms of truth, accountability, reparation, and reconciliation. And I relate these to the components of the reparation, the right to reparation. The structure of my thesis has 2 parts, and it has 9 chapters. The first part deals in analysis the development of the victims' rights to reparation under international law. It also discusses different mechanisms or measures put, either legal or non-legal, put in place by the government of Rwanda to allow the victim of the genocide against the Tutsi to materialize their individual rights to reparation. The second part deals with, this is related to the perception. It has 3 chapters: present and analyze the findings from a qualitative structured interview conducted in Rwanda with 79 genocide victims. As you can see, it is a qualitative, not a quantitative. Then I don't say that this number of victims represent the entire country, but they have their participation in my finding. Finally, the chapter 9 presents the conclusions. So then, as I said, I started by knowing or establishing what is the right to reparation. We have different instruments defining the right to reparation, but when you read all those instruments, they agree that the right to reparations can be divided into these 5 components. The first one is restitution, in terms of restoring the victim to the original situation before the commission of the crime, before the harm. The second is the compensation, here defined as reparation for any economic accessible damages, including physical, moral, loss opportunities. This is how compensation is interpreted. We have also rehabilitation in terms of providing medical, psychological care, or legal social service. Also, fourth, the measure of satisfaction. Here includes public apology, public memorials, perpetrators' accountability. This is part of measure of satisfaction. And we have last what we call guarantee of non-repetition, which includes promotion of mechanism preventing and monitoring social conflicts, also reviewing or reforming laws that may have created conflicts. Then basically, when you talk about rights to reparation, we mean all these 5. And the standard of the reparation coming from the former Court of Justice, International Court of Justice, is that reparation must, as far as possible, wipe out all consequences of illegal and act and reestablish the situation which would, in all probability, have existed if the act had not been committed. Basically, is that. But in my findings, I found that this standard applies on individual violation of human rights. And when it comes to the mass violation of human rights, as it happened in Rwanda, this standard needs some adaptation or adjustment to the situation. That is why I said that the reparation legal standards in international human rights law were not intended to address massive number of victims in conflict. Even if we are considering as a researchers as a standard, but it was not meant for massive violation of human rights with a massive number of victims. Then that's the reason why one of my findings, or what I found out, is that undoing the harm suffered by victims in a way that brings the parties to the statu quo ante is generally not among the range of possibility. Then let's now talk about what the government of Rwanda did. And you will be comparing that to what is meant by reparation, the meaning of reparation. First of all, the government of Rwanda refused deliberately to guarantee an amnesty. And by creating a charter code, by aiming at maximum accountability of perpetrators, the Rwanda put to the end the culture of impunity, and it was the first time that crimes committed against Tutsi were punished. Then, contrary to the South Africa, where they had this kind of amnesty, Rwanda preferred a maximum accountability, individual accountability. And this, in terms of reparation, it acknowledges and confirmed that the victim were harmed, meaning that perpetrators wronged. And this, for the victims, it is a satisfaction. When we go back to the form of reparation, we found that component of satisfaction. Then accountability of perpetrators is also a form of reparation. And this paved the way or created the opportunity for healing wounds of the victim of genocide against the Tutsi. Here, also, the public acknowledge, or the confession from the perpetrators also acknowledge that the wrongful nature of the act committed against the Tutsi. For the sake of time, the second of measure is that in addition to the accountability, which is part of the measure of satisfaction, the government of Rwanda also put in place or preserved the memory of the genocide against the Tutsi through memorial sites, national, regional, international commemoration. This also is a part of the satisfaction measure that the government of Rwanda put in place. And this, it was also confirmed by my empirical research. Victims of genocide against the Tutsi are happy and recognize that memorialization is a part of reparation, and they are satisfied with that. Another thing did by the government of Rwanda is eliminating ethnicity from the Rwandan identity cards, implementing a number of reforms and different strategies addressing preconditions that have occasioned the genocide against the Tutsi. And by that, you know that we have the laws, the government of Rwanda adopted anti-denial laws. It also promoted the unity and the reconciliation through the creation of the Commission of Reconciliation. And this, doing away with the ethnicity, adopting inter-denial laws, and promoting unity and reconciliation among Rwandans have been deemed the best guarantee of non-repetition of ethnic conflict, meaning that these measures fit in the component of the guarantee of non-repetition. For the reparation, the third, in terms of restitution, the government of Rwanda also allowed victims of genocide against the Tutsi to claim the properties or to claim the loss they suffered in terms of property. The only thing that the victims said is that they were not allowed to claim for moral reparation. But moral reparation, as I will explain later, this would have been a burden to the government, and that's the reason why the government of Rwanda, instead of focusing on individual judicial reparation, it is shifted from there to the administrative reparation in terms of through FARJ. And this also answers the last question, whether FARJ is a reparation, can be considered as a reparation. My findings that even if it was not made for that, but all victims interviewed agree that it has a reparative effect. And when compared also to the rehabilitation and the other form of reparation, we found that the FARJ beneficiaries were selected based on their victimhood of genocide against the Tutsi. Yes, to conclude, for the sake of time, the survivors expressed gratitude to the government of Rwanda, but they still have a regret. And this regret is based on the fact that the moral reparation were not provided. But other parts of the reparation were satisfied. Then, let's go to the general finding or to the conclusion. We can say that the measures, different measures I discussed in my thesis, fit in these measures in the definition of reparation. The only thing that is not here, as I said, is the moral reparation. Then to answer the main question, and that is the conclusion, because the main question was to whether victims materialized or to what extent they arise to reparation. Then answering positively or negatively whether the victim of genocide against the Tutsi have fully materialized their rights to reparation would be overlooking the fact that the concept of reparation as developed in international law is overloaded with expectations that are difficult to achieve and to some extent impossible to realize in a post-conflict society such as Rwanda. That's the reason why we say that the Rwanda experience teaches us that there is no one-size-fits-all post-conflict. That's the reason why the Rwandan government adapted within its reality, the societal reality, and come up with these measures, and this what the findings and details on how I reached this conclusion are in my book. It is still free accessible on the website of Groningen. Thank you very much.
Thank you very much, Dr. Sezirahiga, for this brilliant presentation. As a takeaway thing, I've got the TAR, Truth, Accountability, Reparation, and Reconciliation method, or 4-block. Thank you very much. Dr. Eve took us some more time, but I've successfully negotiated with the following speakers to squeeze up to 75% of their time so that we can try to catch up with the time that we have already spent. So I'm now inviting Dr. Didas Kaihura as the first discussant. He will speak from the comfort of his chair. He has no more than 5 minutes. He will be followed by Dr. Etienne Rubebana. Thank you. You have the floor.
Thank you so much, moderator. Honorable Chief Justice, Honorable Minister of Justice and Attorney General, Honorable Prosecutor General, heads of institutions here present, ladies and gentlemen, all protocols observed. After being negotiated to give away 75% of my allotted time, I will not be a discussant as usual, but simply to give kind of information background in regard to the Rwanda Law Journal. I cannot talk about my PhD thesis because probably it requires a second edition by now. And I will not talk about any of the already published articles in the journal, but simply to tell you how it came about. And for your interest as the fraternity of legal minds in the House, to pick an interest for those, especially those of you who haven't gotten to know about it. The Rwanda Law Journal is a journal that was established with the collaboration of the Institute of Legal Practice and Development and the School of Law of the University of Rwanda, and was put in place to allow the bridging of the gap that was existing, especially in relation to law development. I will let the audience know that, as you have heard, as you already know, some of you, the Institute for Legal Practice and Development has law development as one of its core mandates. And certainly it goes along with the ordinary missions of any higher learning institution, because as we know, the traditional missions are training, research, and community outreach. Now, this law journal, the Rwanda Law Journal, comes to especially respond to the two last missions that are there for any higher learning institutions. It came to help in the development of the law by conducting research. And of course, after research, there is the dissemination of the law. And in a way, there is community outreach. But it also came in as another way of specifically dealing with Rwandan legal system, I should say, because we gave it two kind of main parts. One is to carry out and publish through it any ordinary articles, journal article. But the other part, very important, is about the commentaries about the Rwandan, the judgments from courts of law, either in appreciation or in trying to give a critique of the judgments, and all intended to developing the system of law, just like you would expect. But also, it was in a way of kind of implementing the memorandum of understanding we had signed between the Institute of Legal Practice and Development and the University of Rwanda, especially in that aspect of sharing knowledge, supporting each other in terms of research, but also sharing resources where available. Briefly, that's about how the journal came about. So far, we have gotten 2 issues published. The details will be given by the CEO of, I call him the CEO, the chief editor of that journal, Dr. Ruvevana. But as for me, just to abide by the provisions of the negotiations, the outcome of the negotiations, I beg to end by this. Thank you so much.
Honorable Chief Justice and honorable guests, all protocols observed. Let me add on what Dr. Kayihura has mentioned. I will not come back to the rationale for establishing the Rwanda Law Journal because he did it very well. I would rather add what we have done after it was established. This Rwanda Law Journal was established in the framework that he mentioned, and I was privileged to be nominated as the chief editor of it. And with some partnerships with different stakeholders, including some of your institutions present here or represented here, we have managed to come with 2 issues, or to publish 2 issues. The first one was published in 2020. And the second one was established in 2021. And when we started this, we thought it was an easy journey, but this was probably because we did not have enough experience with running journals. So for those who are in the editorial board present here, and others who are in the advisory board, you know how much we struggled with finding reviewers in the first issue, and with some help of one of our, I don't know if he's our alumnus, but at least he was one of our lecturers, Professor Kamatari. He was very instrumental in the publication of the first issue. In the first issue, and this was through helping with the finding reviewers from his university, which is the Ohio Northern University in the USA. And with the second one, we managed to get most reviewers from our colleagues in the faculty, but also in the judiciary and in the other institutions in Rwanda, and we appreciate that. Now, what should be next? We are planning to have a third one. But I would now, because for the issue of time, I will just make a call, not a call for papers now, but call for involvement by different stakeholders. And this involvement could be through different ways, through offering to write articles, but also since most of people here are also representing institutions, it could also be through encouraging the staff to write. There are so many issues that need attention, that may need to be discussed and be published in this journal. So we need to have this journal continue. We need to have it be sustainable. And we in the School of Law and ILPD, we are ready to work with anybody from the stakeholders through co-authoring, but also through co-reviewing. And this is very important. And we are happy that to have our stakeholders from outside and who have also been very instrumental in all our processes. Here I mentioned Professor Marcel Bruce and Dr. Prosper Maguchu Simbarashe from the University of Vrije Universiteit of Amsterdam, and Professor Marcel Bruce is from the University of Groningen, and by the way, my supervisor. And I'm happy to have them today here with us. So, and we have had discussions with them. They are happy also to help in the review processes in the future. But my call remains that we, as stakeholders here, we need to invest in that. Investing in that means investing in money, investing in time, and investing in mindset. Thank you.
Thank you very much for the presentation. And now we are having an online guest that Dr. Hem, is it Batjes, who's the Dean of Vrije Universiteit Amsterdam. Yes.
Honorable guest.
So he's still being put online. We have some technical matters to sort out before he can be heard, but I can assure you that he's already online and he has already started speaking. So we'll ask him to rewind. Is he ready? Okay, Dr. Hem, if you are ready, then we are giving you the floor.
I'm ready. Do you hear me?
Yes, we can hear you.
You can hear me, fine. Honorable Chief Justice and guests of honor, honorable guests, honorable Vice Chancellor, and dear Dean, my name is Hemme Batjes. I am a professor of European Asylum Law and Dean of the Faculty of Law of the Vrije Universiteit Amsterdam. It is a great honor for me to speak at this interface workshop, which I find an excellent platform for academics, policymakers, members of the judiciary, and professionals in the field of law to meet and discuss, to exchange experiences and analyze new developments in your country. Our university, and my faculty in particular, is pleased to collaborate with the justice sector in Rwanda and the School of Law of the University of Rwanda and the Institute of Legal Practice and Development in particular. During their visit to Amsterdam in October last year, we had interesting discussions with our colleagues from Rwanda on law education in Rwanda and in the Netherlands, and on research issues of mutual interest. We are aware that our partners in Rwanda have the ambition to invest more in research, and here we can join hands and work together. Although our context and histories may differ considerably, there are always research topics of common interest that are relevant because new developments in society and changes in the labor market and in business require new responses, new legislations, and new approaches that should be evidence-based and well-researched before being applied in practice. For this reason, I'm very pleased that 2 PhD researchers from Rwanda are being supervised by professors of my faculty. The research projects of these PhD students, Sadiki Bakwaneza and Emmanuel Sudatsinza, concern bankruptcy law. One project addresses the possibilities to reassess current Rwandan bankruptcy law. The idea is to focus on the restructuring of companies in financial distress rather than on liquidation and dissolution of such companies. It concerns comparative research to relevant restructuring law applicable in that respect in the United States of America and in the European Union. The other project undertakes an analytical study of the role of creditors in bankruptcy restructuring. Here, the idea is that bankruptcy law should facilitate a second chance to companies that are viable but financially distressed by availing business turnaround options in bankruptcy legal and regulatory frameworks. If I'm correctly informed, the Rwanda legislature considers reforming Rwandan bankruptcy law, and these research projects intend to contribute to that endeavor. At the Vrije Universiteit, we very much encourage this type of research, that is, research that not only contributes to the body of scientific knowledge, but also aims at delivering societal impact. Furthermore, we think that this form of international academic collaboration is mutually beneficial, since working in an international research team enriches the experiences and brings together different perspectives for all researchers involved. At my own faculty, we continuously try to respond to new societal challenges, both in education and research. To give you a few examples, we have introduced the law in action concept, by which our students are encouraged to apply legal theory to real-life cases. So, for example, we run a number of law clinics in which students, under supervision of our professors, write reports for cases before international courts, such as the International Court of Justice in The Hague, the European Court of Human Rights in Strasbourg, and the European Court of Justice in Luxembourg. This type of contribution is valuable because lawyers often have very little experience with such international procedures and often lack sufficient time and funding, especially when it concerns victims in, for example, environmental law or migration law cases. For our students, working on such projects is a unique experience. And for our staff, it is valuable as well as it contributes to their knowledge and understanding of such international procedures. Another example of our approach is the street law project, in which law students inform specific groups, such as minors who are victims of online stalking or detainees, inform them of their rights. I could name many, many more examples, and maybe sometime we'll be given the opportunity to share these experiences with you in more detail, and vice versa, to learn from you which methods the University of Rwanda and ILPD have to train their students to prepare them for a professional career in law. Again, I thank you for this unique opportunity, and I wish to meet you in person one day, either in the Netherlands or in Rwanda.
Thank you very much, Dr. Hem, for these remarks. And we all hope that now that COVID is almost slowing down, or as we are finding ways to live with it, soon we'll meet so that we can shake hands. So I would like to ask the speakers of the previous session to take their seat as they are waiting for the Q&A session, as I'm also inviting the next panel to take the floor. And this panel will be moderated by Dr. Mulefu Alphonse, that I invite to take place. I also invite Honorable Minister Dr. Ugira Shebuja Emmanuel, Dr. Yusta Kaitesi, the CEO of Rwanda Governance Board, you are also invited to take the floor, and Dr. Kalimunda Muyoboke Eme, who's judge at the Supreme Court. So this panel will discuss the topic of rethinking collective responsibility for legal education, the role of stakeholders. So the moderator, at the same time, I also give you the responsibility to keep time so that we can try to keep our schedule. Thank you.
Thank you very much, moderator. I'm super excited to moderate this high-level panel discussion on collective responsibility for legal education, the role of stakeholders. I don't think that we need much explanation to understand that legal education serves us all, and that where it is not properly done, we, I mean all of us, not just those in different fields of legal practice, but all of us as a society suffer. I know when one talks of responsibility among lawyers, you risk touching on their feelings because the immediate thought is guilty responsibility. And in this case, I want to apologize, that is not our intention. We are only attracting your attention on the roles we can play in the betterment of the legal education in this country, not just at the University of Rwanda. We understand that the purpose of education generally is to contribute in having citizens that are capable of participating in a meaningful way in the life of a nation. The question our esteemed panel will answer is of how best we should contribute. It is not just to contribute, but it is to contribute with a belief that you are part of those who believe that education system can promote our principal values as a society, principles that are reflected in Article 10 of our Constitution, which I may sum up as values that are intended to make Rwanda a fair society. In the words of one American jurist, Justice Abe Fortas, a lawyer is a professional ordained to perform at the crisis time of the life of other people. and almost daily to make moral judgments of greater sensitivity. End of quote. Everybody agrees that a person who is charged with powers to decide on whether you deserve to be compensated or not, or whether you should be sent to prison for the rest of your life or not, such a person needs to have the basic knowledge and skills to limit the room for error. This brings me to the question of whether the legal education gives that assurance. I will not explain more because our guest of honor, the Chief Justice, made an elaborate explanation on that and how frustrated the legal education is and the kind of those that are brought to the legal field are. So we have a great panel, as you've heard. I will give each not more than 3 minutes to make first submissions. As there are 3, that gives us 12 minutes. If you extend, you will not have more than extra 2 minutes, so that makes it 20 minutes. And then the remaining between 10 and 18 minutes will be for discussion. So in the compromise, I've decided to take 20 off. We had 50 minutes. I suggest that we use 30 minutes for the interest of time. Go first, Honorable.
Thank you very much, moderator. The Honorable Chief Justice, and let me also use the phrase, we use precedence in law, the phrase that was used by the Chief Justice, all protocols observed. Let me take this opportunity to profoundly thank the School of Law for having invited me to participate in this noble interface workshop meeting. When you're invited as a former dean, you always have mixed feelings. You tend to look back and reflect on whether you would have done more during the time when you are dean. So that makes you feel guilty, as you earlier pointed out. But at the same time, you are very proud of where the School of Law is. And you also do feel that you have a responsibility in the position that you are in to support the School of Law to grow from strength to strength. So those are the mixed feelings that you have when you're invited to give this talk. Let me begin by saying that justice and rule of law are like a garden, and they do require watering and tendering too in a constant and never-ending approach in any given society. And working upon this garden is an array of members of the legal community, which includes legal academics, law students, legal professionals, and judges. Despite the importance of maintaining the rule of law and justice, there is a diversity in the outlook and approach by all the members of the legal community in this endeavor, which requires to be bridged. I cannot capture this sentiment more eloquently than a friend of mine who is a former Chief Justice of Australia, Chief Justice Gleeson, who was invited to officiate the launch of a book called the Oxford Companion to the High Court of Australia. And the book had been authored by different people from different areas of the legal fraternity. And he stated as such, I want to quote what he stated because it captures the mood of this panel. He stated that what is fascinating is the contrast between the approaches of different authors to similar topics. There is a good deal of overlap between the various subjects addressed in the book, and I have enjoyed comparing what different people have had to say about the same or closely related topic. Some of the authors are law professors and others are legal practitioners, Some are both. One thing that struck me is the gulf that exists between the view of legal institutions and the court from within the universities and the view from without, that is in the practicing legal profession. Each side has much to learn from each other, but I wonder if people on either side of the gulf realize how wide and deep it is. It suggests to me the need for some bridge building. So I think this is the importance of this particular panel. How do we bridge build between the academia and the legal fraternity, that's the practitioners? It is often said that the relationship between academic lawyers and especially the judiciary has traditionally been remarkably distant. With few exceptions, the status of academic lawyer was, at least until the mid 21st century, or 20th century, sorry, had been very low, and until recently it would have been rare for a judge to cite the work of a living academic author. That was very rare until very recently. It was even quite rare to find academics being friends of the court and helping the court to be able to arrive at a very good judgment. But now it's beginning to be a practice, and especially here in Rwanda, and I'm very happy that the law school has been part of that move towards being friends of the court. It is gratifying to note that the University of Rwanda Law School is playing a major role of bridge builders by creating a forum such as this to share the experiences and practices, not only from different components of the legal community, such as judges, legal practitioners, parliamentarians, and academicians. I do believe that this forum is quite important. The purpose of this session, and I want to respect the minutes that you've given me, is reviewing things that can be done in a practical way to foster and encourage cooperation, collaboration, and the effective interchange of ideas between the legal fraternity and the academia in the quest for the betterment of the legal education in Rwanda. I do believe that we can develop a partnership model which would involve law schools and the legal fraternity in the following manner. The first manner is that there should be encouragement of legal practitioners to teach in law schools as adjunct professor and in clinical and ethical courses. The American Bar Association Professionalism Committee has recommended the use of highly respected judges and practitioners as adjunct professors. This can help expose students in the classroom to the practical perspective of experienced practitioners and enable faculty to benefit from a period of practice. I do believe also that there should be development of a system for judges and senior practitioners to spend periods of time as visiting academic fellows at university law schools. Judges and senior legal practitioners can be provided with office accommodation and give a couple of lectures, including public lectures, participate in a staff seminar, and otherwise engage in informal discussions with staff and students. I also do believe that there should be development of a system under which academics could be visitors to particular courts or even established legal chambers for a suitable period. The visitor would have the opportunity to observe cases and subject to appropriate protocols, to talk with senior judges and associates arising in the case. The protocol will have to be formulated with some care to deal with issues of confidentiality and conflict of interests if you are, for example, dealing with courts. There should be interaction of practitioners with law schools in activities such as presiding over moot courts and moot trials and in teaching. I also do believe that the legal practitioners can participate in law school panel discussions, students' clubs, and mentorship programs of students. Clerkship is also very important. I was surprised that when I was still at the bench at the East African Court of Justice, I had students from all over the world coming to clerk at the court, but not quite often from Africa, so this is something we have to deal with. But in order to achieve this new way of partnering, certain old practices which don't suit the times that we live in have to be discarded. Vice Chancellor, you'll admit me to be a bit frank here when I discuss some of these old practices that we find in universities. And not only in the University of Rwanda, because I do remember one of the rectors of Leiden in one of the conferences that I was in. He said that trying to move a graveside, trying to move a university is sometimes the same as trying to move a graveside. Sometimes the people inside do not offer you a lot of help. So we need to discard some of the old practices. One of the old practices is the manner in which bureaucratic bottlenecks do hinder some of the projects. Some of us who are now in the policy-making seat and who came from university, we do understand how bottlenecks, especially the bureaucratic bottlenecks, really hindered professors or even lecturers from pursuing projects. Because, and I'll give one component of this, once the funding comes to the university, it has to follow old rules which delay the projects. And if you are a policy maker, you are very agitated when the projects are delayed. So a way has to be looked into on how projects are managed once they reach the university if you want to establish this partnership. The second one is the issue of promotions of people who are in the field of legal academia. If we want to have this partnership, we should encourage a mode whereby certain unconventional outcomes should be considered when someone is being promoted. If someone, for example, is a friend of the court and has come up with a very good submission, I do believe that should be considered as part of their promotion, as opposed to traditional papers which sometimes law professors only write for their own good or within their specialty that they are in. Then we should also, maybe I shouldn't go deeper into this, some of them I'll discuss with the Vice Chancellor. But also in the way we structure our legal field, why would it not be possible for law lecturers to be part-time judges sometimes, especially in the specialized areas such as competition law, or even when we have a backlog in the courts, especially those who are not in practice? I do believe that that is also possible. And finally, I do implore upon the School of Law not to have an annual event such as this. I do believe that we can have maybe every 2 months have a forum such as this to reflect on a topical issue, just like we had P and Eve reflect on issues, but you saw that we were trying to ask them to be fast because we don't have enough time. So if we have enough time, maybe every 2 months, to have a forum such as this, which brings us together, I do believe that this would be a practical way to go forward. Let me conclude by saying that the ongoing efforts of the School of Law to shape and improve legal education are truly impressive. It is a great endeavor you all undertake, and I do take this opportunity to wish you well with it. Thank you very much.
Thank you very much. I will not go back to what he just said, but I don't want to miss the fact that he mentioned that it is the two-way traffic. So to the benefit of the practice, but also to the benefit of the schools of law. And someone from the Netherlands who will speak, I would want him to talk about the aspect of ad hoc judges, because I know it works in the Netherlands where academia sit on certain cases. Thank you. Dr. Ust.
Thank you very much, moderator, the Chief Justice, the Vice Chancellor of the University of Rwanda, taking precedence as a rule, all protocols observed. I also want to thank the organizers of this interface. And I will honestly tell you that I feel so marginalized. I did not realize that the law school and the legal profession was so male. Maybe it was also one of my faults because I spent so much time at the law school. I should have seen that. So I will definitely take the blame. I kept thinking if I didn't just want to, I wanted to put on my microphone and mute it and make the women's voice as silent as it looks. But I think that would be a disfavor to that voice, but I start with that voice. I start with a voice that when we are in an interface, we are also looking about stakeholders and about inclusion, which you referred to when you spoke about Article 10 of the Constitution of the Republic of Rwanda, and about the future. And I want to really remind ourselves that the future lawyers, the future chief justices, prosecutor generals, presidents of the Bar Association, justices in the room, I probably am one of those few who sit in an office that doesn't necessarily require a lawyer, of all the alumni in this room. For many of you, your offices require being a lawyer. Who are we handing over to? And how are we preparing the handover? Do we feel confident on how these people are being prepared? And I really appreciate why we are in this room. I think we are really talking about a very key element on rethinking how we prepare those we are going to be handing over. I often get frustrated when we all sit out there and complain that the current products are not right. We are supposed to be generating the products, either by preparing them on how they get there, by engaging when we are there, and by proudly feeling that we will take over. The picture that Dr. Mbembe showed of the posh cars and the house of the parents, I kept wondering what I'm not doing right as a parent. I think I'm at the stage of thinking more as a parent and less of as a child. And I kept wondering what I'm not doing right as a parent, that will let my children enjoy being in posh cars and only coming to get embarrassed at my home. So I wanted to look at it from that two-way approach. How is home accessible? What makes us have lived in that home dearly, having gained from what we gained, and not willing to come and improve our homes? And that is on processes. I think the Honorable Minister really gave it a fair judgment. I also wanted us to remember that we become lawyers at law schools. Our first true ambitions of being a lawyer are before we enter law school. Our real dream is when we leave law school, not when we leave with PhDs. That is when we become academics. But when we leave with a first degree, we get the pride of being called a lawyer. And I think it's there that we have to really create the ambition. So the ambitions and philosophies of the next generation of lawyers are only going to be created at law schools. And it is the question that we have to move back to that. We have to move back and think, what are we not doing right to really consider the child at birth? Because even the bar only admits us for the first degree mostly, not for other degrees that we get into. So, but I wanted to bring that to the issue of curriculum. While I really think it's key that we create the ambitions, that we create the philosophies, that we instill the values of the next generation of lawyers, I also want to think of the curriculum. We as stakeholders, in private, in public, in civil society, how much are we interrogating the curriculum and being able to respond? I'm living in a world of practice that I never lived in, which is being a regulator of political organizations, of the civil society, of the faith-based organizations, and I have a whole range of laws that we hardly teach in the law school. We do introductions of that in the constitutional laws mostly, but this set of 5 laws that I engage with every day does not have any expertise. We therefore do not even prepare our students to see the new niches. You know, in the morning we were talking about the foundation law with my colleague Butare, and I'm sure it's not on the space of the curriculum. And development is going to that direction. So I think also unlearning what we have learned as academics and engaging with the practitioners to speak about the law that is relevant and the direction of the law is a key element. And that's why I really appreciate the opportunity for us to speak in this interface. The discussion on professionalism and sustainable service delivery is key, but that comes with the nature of where the lawyers are going and who they become when they go there. So I also wanted to really come back to the elements of the new developments. The world is changing, and so should the law curriculum. The values and professionalism of the lawyers shouldn't change, but the kind of responses that lawyers should be making today should adjust to new realities. Data protection does not appear the same as it used to be in the old days when the right to privacy was the overriding right. Today, the intrusion of the new technologies makes our privacy totally a different way of engagement. And I think thinking of the legal world from that direction is also a key element. So I wanted, keeping it to the limits that we are partners. One of the elements of the Constitution that I love so much. And before I rethink, I want also to think that we have to engage, to intentionally engage. And I appreciate this initiative of engaging, but we initially do not have a relationship, I must say. And keeping the relationship is the basis of engagement. Secondly, I don't want us to be called stakeholders. It's another thing. I want us to feel like we are partners. Partners in generating students, partners in equipping them, and partners in receiving them as your product, as your product to us, but also as informing the product that we get. And I guess that partnership that this stakeholders meeting represents is the biggest way to go. If we have the space for partnership and have the opportunity to engage, the other is just content that we can easily develop. Thank you very much.
Thank you very much. How is the university prepared to receive, to create the environment that allows those in practice to provide their support? And the continuous curriculum review, I was talking in the break with the president of the bar, and he was promising to come to join the school to provide some support, and I hope he's going to come with his other colleagues. But how prepared are we? And I think that is what Dr. Yusta was trying to highlight, and many other things that you had that I will not attempt to speak on. Justice.
Thank you, moderator. Honorable Chief Justice, all protocol observed. I'm very humbled by the opportunity to be speaking in this gathering. I know it isn't easy to, I should maybe have changed the sitting position and be close to the moderator. It isn't easy to speak after the Honorable Minister of Justice and Dr. Yusta Kaitesi, who both were in academia before me, and they hold positions which has likely helped them to develop their eloquency. The judges we normally are used to read our judgments So, but I think I will build on key elements that were highlighted in the speech of the Honorable Chief Justice. The concern we have today in the legal fraternity. We have two major concerns, the issue of competence and ethics. And I think these are two aspects which are crucial to all of us and even others who are not here. Because by embarking in the law schools, it is because we all believe that we believed in the phrase of Daniel Webster, who says that justice is the greatest concern of man on earth. And it is this concern indeed which was present, I think, in the 16th century in England, when King Henry VI was almost facing a threat of being overthrown, because there was a perversion of lawyers. Lawyers were maintaining the privileges of the wealthy and the powerful. Lawyers were standing in the way of violence. The process towards the rule of law was so bureaucratic and perverse, to the extent that in his play, William Shakespeare said that the best way to address the perversity of the legal fraternity was to kill all lawyers. So, but by by stating that the need was to kill all lawyers, he did not intend to murder all lawyers indeed. He rather was paying tribute or homage to lawyers as defenders of rights of citizens and rights of companies, as protectors also of individual rights. And I think this is the mission we all have, law schools, all institutions gathered here. This is the mission we all have. I remember a quote from Adolf Hitler, yearly before the Holocaust. He said that I shall not rest until every German sees that it is shameful to be a lawyer. That's Adolf Hitler. So I think these are aspects which should in fact raise the conscience of all of us and look or find ways of strengthening the legal education. Because you might not be killing the lawyer physically, but you might kill the law or the legal spirit inside the lawyer, and at the end of the day, get an empty product. So, for not to keep being too long, I would like to suggest a few recommendations which I believe can help. In my humble view, there is a distance between the current curriculum in the law schools and the needs of practice in the workplace. Most of the time, we find that the law graduates are not fitting the positions they're applying for. So this requires most likely the university and most specifically the law school to interact with the end users of their products. Starting, of course, with the Minister of Justice, the Judiciary, the NPPA, and so on. But I also believe that it will be easier for a judge to teach legal deontology in the law school than it would be for a law professor to teach judges deontology. I think it is important for all these crucial issues that are being raised today that we take part of the blame, indeed, like it has been mentioned. Yesterday, there was a colloquium or a symposium on the corruption and the human rights. And all justice institutions were listed, including the judiciary, the NPPA. Of course, with minimum statistics below 10% of corruption, but I think we should be at the rate of 0% in the justice sector. We shouldn't be happy that the judiciary is at a rate of 60% corruption, or the NPPA is at the rate of 8%. I think we should be at the rate of 0%. But which role are the prosecutors? Which role are the judges are playing in building an ethical lawyer who will come to become a judge or a prosecutor tomorrow? I think, Honorable Chief Justice, that there has been also a gap in the process of building a legacy. We have had respectable Rwandan lawyers who have never been acknowledged, whereas they have contributed a lot in a society, and the work they have done is not acknowledged. I think it is important that at the level of institutions or even the law schools, we recognize through prices to students in some areas the work which has been done by our respected lawyers. I can give you a few examples. We have, for example, the Chief Justice Kavaruganda. I don't know the Christian name, I'm sorry. We have, for example, the retiring, we have a couple of Chief Justices who have retired. We have a couple of professors of the law schools who have died, and there is nothing which is being done to recognize them. I have seen that in other law schools, there are names of these people, and we have, for example, prizes in constitutional and democracy for Mandela in South Africa. We have prizes in commercial law. We have prizes in international law. And I think it is something which can emulate the student at the level of the law schools. I think also that it is important that at the level of the law schools, we strive for excellency. We have followed the speech by the dean, and we have also followed the speech by the principal. But we don't know whether there is a policy at the school level or even at the university level of promoting the excellency of the academic staff we have. I think it is important that at a certain time we have scholars, respected Rwandan scholars in specific areas, and that this can come only if we support it. I think it is important that we have a reference in constitutional law, we have a reference in international law, we have reference in commercial law, and we stop quoting books from the laws, from Oxford University Press, from Cambridge University Press, because we have developed our own capacities. But I haven't heard that, maybe there is, maybe it is myself who was not following. I was thinking that something which could help also would be creating specialized institute. So far, the law school has been created in 1973. It has produced thousands of lawyers already on the market. But I think it is time now that the law school think about creating specialized institute. And for example, this institute can be even founded through a program like this one of alumni, through the foundations, and through other people who can support this kind of institute. I saw that in the Netherlands, something which is helping this collaboration between practitioner institutions, the judiciary and the academia, is the existence of this institute, specialized institute, which are able to get extra fund and enter easily in partnership with the outside world without going through the bureaucracy that Honorable Minister was mentioning. Thank you, sir.
Thank you very much, Justice. Emphasis on ethical considerations in our teachings, attitude, discipline, recognition of individuals who have exceptionally contributed to the legal environment, references in specific fields, and I would add on that those reference persons also should create communities in those specific fields, because you cannot think alone. I invite because each individual's submission has attracted your attention and made you reflect on what the other has said. I give each one of you 1 minute to respond or make some clarifications as we conclude. I start with you, Honorable Minister. 1 minute.
Yes, thank you very much, moderators, and I'm really glad that my co-panelists have touched on areas which are key. But since we only have 1 minute, let me say this. We know what we are supposed to do. We've been talking about it, but the challenge ahead is when are we going to do it? When are we going to put it in action? I do remember, and the Chief Justice rightly pointed out, we spent quite a number of dinners when we were both in Arusha, discussing about how we could contribute to the enhancement of the legal education. And we were discussing exactly this topic that we have today. We were not then in the positions that we are in. And I do believe that most of us are in key positions which enable us to push the frontier of what we are talking about. So let's do it. Let's stop. We should stop talking about it.
Thank you very much. I also want to say that partnership is the way to go. We all have echoed our interest in being part of this. And I really think if we have one thing to take away as the alumni, this could be our initial project. The project of influencing one another for a better legal future, and the opportunity of using our resources, both intellectually and financially, to create a better legal education environment. Thank you.
Thank you. Among those who strongly believe that this initiative can be materialized and it is possible.
Thank you all very much. Join me in thanking our great panel. Thank you very much.
Now, it's time for us to receive Professor Marcel Bruce from Groningen University and Professor Kalula, who unfortunately couldn't make it to Kigali, and he is unable to do it online, but lucky enough, he sent us his remarks that will be read by the Dean of the School. Dr. Bruce, you can take the floor. Dr. Vikesha, you can also take the floor on behalf of Professor Kalula. So in addition to sharing experience on running a PhD, Dr. Bruce will also do a comment on the ad hoc judges in the Netherlands, as requested by Dr. Mulefu.
Thank you so much. That will be a challenge in the 15 minutes allotted to me. Your Excellencies, colleagues, participants, friends, thank you for inviting me to come here to speak and to share some of my experience in my academic career. I have had an academic career only. I haven't practiced, so I'm really a pure academic. But I have some experiences which I'm very happy to share with you. I think I heard so many interesting things today, but with many things I agree, and some I disagree or see differently. But also striking is how similar the debates are, which you are having here, as we are having them also in the Netherlands. I was invited to say something about ad hoc judges. It's a bit difficult because I'm doing public international law, and to be an ad hoc judge at the International Court of Justice, there are ad hoc judges, but there's only a very few of them, and they are very, I'm not an expert who will be called to be an ad hoc judge in the International Court of Justice, but I know that many of my colleagues in the law school, they act as an ad hoc judge. So that means that a day in a week, in a month or so, they sit in actual cases. It helps the judiciary to work with backlogs, but also brings in a different perspective and a different idea about a more academic perspective on some of the cases they have. And that's an important contribution. On the other hand, those people who are practicing, who are ad hoc judges, they bring in that experience to the classroom, of course. So it's a very, I think, very fruitful and successful. Since I'm not involved in it, I cannot say much more about that. But if someone is interested in it, I can easily bring you into contact with certain people who have that experience. I'm invited here to share my expertise with running a PhD program. Now, one thing I have not done is run a PhD program. But I have quite a lot of expertise in PhD programs, starting with my own PhD, where I was a guinea pig. That was in the second half of the 1980s. Then in the Netherlands, they invented something like PhD programs. And before that, it was the supervisor with a PhD candidate. You find out how you do it and what comes out of it. We don't bother with that. But then there should be more PhDs. It should be better training. So I was a guinea pig in the first training program, which was still not very good. It was purely content-related, knowledge-based, you could say. After that, and after my defense of my PhD, I did some work at Oxford University, and there I had my first PhD students to supervise. And that was another experience in a different context. So I learned from a different perspective as well, how you can do things differently than that we do it in the Netherlands. At the same time, I was designing a new PhD program, a bit similar to what I experienced in Oxford. I designed that for Leiden University. But unfortunately, when it came into operation, I already had left and took up my position in the Groningen University. And there I especially participated in supervising PhD, but also in examining, so as Etienne and Yves here have experienced. And besides that, in the Groningen University, I'm a member of what we call the Committee on Scientific Research. That's the highest advisory body for the faculty on research. And that has also an active role in our PhD program. I'll come back to that in a moment. I would like to focus on 4 essential objectives of what I think is a good PhD program. But before doing that, I would like to make a preliminary remark. Namely, there is not one PhD. There's so many different PhDs. A PhD from Rwanda, from South Africa, from Germany, from France, from England, from the Netherlands, from the United States. They're all different. Sometimes 2 years, sometimes 4 years. You cannot easily say, but I hope that the comments I want to make are applicable to all kinds of PhD programs. Second one, that I want to throw a big stone through a window. Which you might like or not like, but one thing is, for me, PhD research, writing a PhD dissertation, is not about the result. We have heard about interesting PhD projects which were summarized here. And that, of course, but for me, that's a bycatch. Bycatch that there was a good outcome. The main purpose of a PhD program is that's a learning objective. The candidate experience is something which brings him a new perspective on what he will do or she will do after doing the PhD. The dissertation, the book, is interesting, but that's not what is, for me, the most important of a PhD program. I have 4 points which I want to say briefly something about, and that is a PhD program is about assisting the candidate. Secondly, the PhD program is about creating a learning community. Thirdly, it is about providing professional development, both for the candidate as well as for the supervisors. We should not forget that. And fourthly, a PhD program is important to have clarity about roles, responsibilities, and processes. That is what I experienced and where I saw in the past years when in Groningen, when I came there in 2005, they started with a new PhD program. It developed over the time, and we'll see what we had some things which went back. We did not go very well, but some things were very successful. But now I think we found quite a good balance. Let me say a few things about assisting the candidate. That is about providing training to a candidate, that there is some kind of minimum requirements that the candidate has to engage in. That can be partly related to content, doing some extra expert law classes or courses, but it is primarily on skills, and we have also heard it sometimes mentioned today, it's about integrity and ethics of a scholar, but also generally of a professional. What is also, that's the first point, that's the program for, that you try to put that in a program. You give, in Groningen, in the Groningen Graduate School of Law, students have to obtain 30 credits, some on substance, some on skills, some on ethics and integrity. But that program is not a one-size-fits-all. It is very flexible. And it is really looking at the candidate, what does that person need in order to be successful as a PhD candidate? And that is what we try to look at. Because sometimes you hear about PhD programs where they first have to do a particular series of courses. If that's not relevant for your PhD, don't start doing that course. Don't waste your time. Just go to what you want to do in your research project. Second point on assisting the candidate is being alert on early warning signals that things are not going well in the conduct of the research, in the relationship with the supervisor, maybe even private life issues, or what is very important nowadays, PhD candidates are very much under stress, mental issues. That is it takes a lot of time from those who are running a PhD program, taking care of that and also having early warning systems, being alert to that. And thirdly, it is creating a safety net. What do you do when the process is not so successful? What is then the exit strategy for the candidate? Or when there is a delay, how do you solve that if there's only for 4-year funding? That's also very important to have in a PhD project. And linked to that, the safety net, is the confidentiality officer. In Groningen University, we have, or in our faculty, we have introduced recently for the PhD program a special confidentiality officer, where a PhD candidate having issues with his or her supervisor, or with even the graduate school director, can go to that person who happens to be the former graduate school director and really speak in private about these problems. She is 63, has very gray hair, so we call her the grandmother of the PhD program. Very important to have such a person where people can have trust in. And finally, the PhD program has to give practical support to the candidates by having a small budget available for some conference visits, or maybe even helping with purchasing a laptop or so. Creating the learning community, the second one. I have to speed up a bit, otherwise my 15 minutes will be up before I know. One thing is we start with startup groups. We have cohorts. Of course, there are more than 100 PhDs in our program, so that is a matter of size. But when some number of people start together, they are a startup group. And from moment one, they start sharing their experiences, sharing experiences. That is so important for successful PhD projects. Immediately, avoiding that a PhD candidate enters into an isolation. And also sometimes there's some opposition to that, because why would someone who's doing a PhD on private law be interested in doing a PhD on someone who does international criminal law? What do they have in common? Why should they be in one startup group? Through diversity, you create creativity. And that is also important to open up the minds of the candidates. Secondly, PhDs should be engaged in all kinds of activities like conferences, meetings, social activities that can be internal within the faculty, external within the state. We have, for example, our Netherlands network on international human rights research. There, the PhDs active in human rights research participate in that. But also we have, with other universities in Europe, we have the G4 and the G8, where PhDs regularly meet once or twice a year, where they exchange their projects, they make presentations, so they learn a lot there. Don't stay in your own bubble. Organizing activities, that was also the PhD programs. The Minister of Justice was mentioning that should be also engaging with practice, but also in a PhD program, the PhDs or the director could invite people from practice to also share with them their experiences. Very important, sharing frustrations, and that is also to have a safety valve, you could say. Coming to professional development, the third point of my objectives of the PhD program, that is first offer some additional training. That is substantive, expert courses, I mentioned that already. That can be in the university itself, can be also external, facilitate that. That's broadening the legal knowledge base. It can be important. But more important even is the skills training, and you all know about that, how important it is, the writing, argumentation, presentation, methodology, language publishing. Some have to be developed especially for your university. Some are developed especially for your faculty. Some are for a particular aspect of let's say, legal empirical methods. That is not so common. So maybe it can be also between various universities that you have a particular course on that or particular training on that. Third point on professional development, which is important in the PhD program, is to create career awareness. Life doesn't stop when you get your PhD degree. You have to be prepared for what you do after that. And of course, some want to go into legal practice. You don't have to become an academic. Other ones want to do something different. So you have to be preparing for that as well. And also then there is the academic integrity and ethics issues. And here we come to the supervisor, also in the professional development aspect, is to train the trainers again, make sure that the supervisor is professional in how he deals with that. I can say more about how we do that in Groningen, but with the view on time, I will be skipping that. If you are interested in it, I can tell you much more later on. Fourth point, last point, the clear roles, responsibility, and processes. Roles and responsibilities, it's clear that from the start it should be clear what is expected of the candidate. What should she achieve or he? What is the role of the supervisors? We always have two supervisors. There's never one supervisor anymore in Groningen University, in order to avoid the conflicts and problems between the supervisor and the candidate, and also to have more input. Then is there the director of the program with a special role. There's the confidentiality officer and the committee of scientific research. And that last one is important in the process. So we have defined roles and responsibilities. PhD candidates are informed about that from the beginning and we know where to turn to with what aspect. And then there's the processes. And that starts with the criteria and the time frame for selection, for starting. For example, if a PhD new one starts, has to write a proposal. That proposal is written together with the supervisor. Then it goes to that committee for scientific research, and they review it, give constructive feedback, and they say, this is not yet good enough. You have to do more work. This is a conditional approval. You have to do this or that thing, and then it's okay. Or it is a straight approval. It doesn't happen too often. So there is review of the reviewers. Do the supervisors, have they thought enough about the project in order to make sure that it is viable, that the candidate can do it in the allotted time for that? Starting it, and then after 9 months or one year, we have the go, no-go moment, and there the director of the graduate program is very important. The student has to present the final outline of the whole project and first drafts of first chapters or articles or whatever they use. And then it will be decided between the director and the supervisors whether for that person it is perhaps better to stop or whether it is okay to continue. You should stop early. If you stop too late, then a lot of damage is done, and you cannot say to two persons who you have worked with after 3 years that, nah, I saw that coming, that you were not so good, and now we stop the whole process. You cannot throw away lives of years of the lives of people. Yearly progress reports are important, and of course the formalities of the defense must be very clearly regulated. My final remark, and I think, yeah, maybe a bit over time, but not too much, I hope. Final remark, there is not one ideal program. I just gave you a few things so as I have experienced it and what I think is good practice, but the reality is complex. Each supervisor, candidate's relationship is different, and the difficulties are also difficult. The most important for a PhD program is to avoid casualties on the way, so that people that drop out, that there is really people have all kinds of difficulties as a result of being engaged in a PhD program. And the core lesson, and that's how I wanted to give to you what I learned in all these years being involved in PhD supervision and programs, is don't leave the candidate at the mercy of the supervisor. Make sure that there is a whole framework within which the supervisor and the candidate work. Because many times, even if the supervisor is full with good intentions, it can go wrong without the supervisor even know that it goes wrong. And so make sure that you have, that's the idea, that's the role of the PhD program, to make sure that there is a good environment in which the PhD can do his or her work. And that's what I wanted to share with you. Thank you for your attention.
Thank you very much, Professor Bruce, for this. Yeah, you can take your place. So now we'll hear from the Dean, who will be reading the remarks prepared and sent by Professor Kalula.
The residence is going to work. I observe all protocols on behalf of Professor Karura, and the assumption is that Professor Karura is speaking now. Greetings from an overcast but mild Geneva with the spring in the air. Good afternoon. It's a great honor and privilege to be part of this conference. It is particularly gratifying that this is an alumni gathering, a constituency close to my heart. I'm very sorry that I could not share my brief thoughts with you in person, albeit virtually. Please kindly accept my sincere apologies. I'm most grateful that the Dean, Dr. Dennis Vichesha, has kindly agreed to make the presentation on my behalf. Before I share my eclectic thoughts, such as the year, please allow me first to thank the Vice Chancellor for the opportunity to serve as honorary professor in the School of Law, to render whatever modest assistance I can in the development of what undoubtedly has all the hallmarks of becoming a great law school. Thank you, Vice Chancellor. I'm equally grateful to the Dean and his colleagues for kindly welcoming me to serve in this role. I sincerely believe the sky is the limit for the school, and as it happens, the PhD program is a core element of its development. I therefore feel honored and privileged to be present at the creation, so to speak. It is befitting that the School of Law should seek to share comparative PhD experiences as it sets out on this worthwhile endeavor, which is a critical academic pursuit, defining as it does not only the place of the school in the League of Law Schools, but even more importantly, its contribution to knowledge production and national development in Rwanda. I would like to briefly share my experience of running and participating in the PhD program as a student, academic administrator, and supervisor at a number of universities in the UK and South Africa, including the universities of London, Oxford, Warwick, and Cape Town. But my major experience is particularly drawn from the University of Cape Town, UCT, where I have been privileged to spend about 30 years as a law teacher, academic administrator, and supervisor. I have also been privileged to supervise at other universities besides UCT, including the University of South Africa, UNISA, University of Johannesburg, UJ, University of Zambia, UNZA, University of Lusaka, University of Wits, and National University of Lesotho. The University of Cape Town is widely recognized as the Africa top-ranked university all around, but particularly in research outputs. I have been privileged to supervise and co-supervise over 40 PhDs over a period of 30 years that I have been associated with the Faculty of Law there. I would therefore like to briefly share my sense of the nature of a PhD, various approaches to program design, outcomes, and most importantly, the kind of lessons a new PhD program such as the law is embarking upon should draw on. The PhD project comes in different forms and is built on various particular settings of universities and national systems of higher education and research. However, common to all such programs is essentially the provision of a platform for advanced training in research and for knowledge production and innovation. The PhD is therefore the highest form of learning. There are some key factors to PhD study, including structure, student preparedness, research facilities, and supervision. In the current environment of technological advancement, some of these factors are more available than others. In law, for instance, information gathering for desktop research is now much easier to access, and coupled with empirical research, it is therefore less cumbersome. However, I should hasten to add that traditional sources of research materials such as good libraries are still key, particularly for a new law school. The structure of a PhD program is of great importance. Many PhD programs now provide more extensive induction activities to prepare candidates for research. Such activities vary on structure. They include theory and research methods, for instance. It is not unusual to have partially taught PhD programs with the research component amounting to a dissertation rather than a thesis. At the University of Cape Town, the Faculty of Law has maintained its magisterial thesis approach, but it has enhanced student orientation and specialized cohorts focusing on common themes of research. Elsewhere in the university, for example, the School of Economics, there is now a particular taught PhD program, a partially taught PhD program, sorry. Supervision is of overwhelming importance, particularly for new law schools like at the University of Rwanda, where being a younger school, there isn't enough potential supervisors. The cohort of staff able to supervise will, of course, progressively increase, but not as quickly as the need right now. Even at an old law faculty such as UCT, not all areas are catered for. What could be done to ensure that the PhD program at the University of Rwanda has a credible beginning? The establishment of a global faculty would not only be to draw on additional supervision capacity from outside internationally, but also train and mentor emerging young faculty in the school. The University of Cape Town makes extensive use of external faculty in the form of adjunct professors, honorary professors, visiting professors, and adjunct PhD programs with other universities. Incidentally, the global faculty approach has been successfully used by such other leading universities as New York University in not only enhancing its already considered profile worldwide, but adding to its expertise in a wider range of research and teaching areas. The School of Law here could therefore consider expanding its external faculty support, and equally important, its collaborative links. It is gratifying that the school is already seeking to renew its collaboration with the University of Cape Town, for instance. There is no doubt that the School of Law occupies a special place in Rwanda's development, not only as a source of graduates who will get into legal practice, but also as a source of expertise in the development of national policies. As such, the need to relate more closely, not only with the legal fraternity, but also other sectors and the broader society is imperative. Adjunct professors and part-time instructors, not only on teaching, but also in research, is of great importance. A PhD program can also be an impetus for research and outputs. Publications are key. The school would do well to encourage the publication of research, not only by emerging faculty researchers, but students as well. The need for credible outlets for research, such research is crucial. The school already has plans of a law journal that project needs to be accelerated. Another plan is that of developing partnership with JUTA, a leading legal publisher based in South Africa. Such collaboration would lead not only to the publication of the law journal in the JUTA's stable, but other research outputs. The Dean, Dr. Dennis Vichesha, has already led the way in that respect with a well-researched book on the Gacaca courts in the JUTA press. In conclusion, this is an eclectic outline of a comparative experience with the hopeful the school could draw on along with the other experiences. I'm most grateful to the opportunity to share these impressions with the conference. Once again, my sincere thanks to the Dean, Dr. Vichesha, for kindly making the presentation on my behalf. Thank you. Emeritus Professor Evans Karura, Honorary Professor of Law, University of Rwanda, Geneva, 18 March 2022.
Thank you very much, Professor Karura, for your remarks. Yes, okay, so let's continue our journey. After these very insightful and very rich experiences shared with us on running a PhD program, I would like to invite Dr. Etienne Ruvevana, who will be moderating the panel that will discuss the visibility of the School of Law in terms of infrastructure, whose responsibility to take the floor. He will also, as he's still wrapping up, I will take also this privilege to invite Professor Alexandre Liambavaje, Vice Chancellor of the University of Rwanda, to take the floor. I'm also inviting Honorable Chief Justice to also take the floor. Maître Boutare Emmanuel, you are also invited to have a seat at the front. And Dr. Prosper Maguchu, please have a seat here at the front. So this being said, I'm handing this session to Dr. Etienne.
Good afternoon, Honorable Chief Justice and other members of this panel, and Honorable other guests, all protocols observed as we go the formula. Thank you so much for being here for this discussion. I'm going to moderate this panel, and which is discussing about the visibility of the School of Law in terms of infrastructure. And the question is, there is an implicit question there, whether the visibility of the School of Law can be seen from the infrastructure, but there is also an explicit question, which is whose role, whose responsibility to make that infrastructure accessible for the School of Law to be visible. So we have had other discussions and with the concrete suggestions, especially the panel on rethinking the legal education in Rwanda. So there are many questions that were raised which are very relevant, and I will just come back to some of them, which include the questions on who are we handing over what we are doing, and also how are we preparing them to be ready to be handed over what we are doing or what we have been doing. And now the question will be, where are we preparing them from? So the earlier questions were about who are we preparing and how are we preparing them. But now there is another relevant question of where we are preparing them from, because these can determine who or what product we get. Because if you take the example of some other disciplines, for instance, the medicine and other disciplines, it may be that students with good laboratories will be trained well in order to perform their task after their graduation, after they have completed their studies. So the question of where are we preparing them from is very key, because where we are preparing them from may determine the product that will come from that place. Maybe for the interest of time, I will go very quickly. Dr. Elvis started in the morning with an he improvised with something which I did not know, but I thank him for having done that. Of this home, the accessibility of our homes. What is our home? And he indeed asked some questions to the members here, or to the participant here, of whether they know where the School of Law belongs or where it is located. So he mentioned a number of locations, saying, is it located in Kigali? Is it located in Gikondo? Is it located in Huye? Is it located in the main campus of Huye? Is it located in Ex-Rectorat? Is it located in ISAP? Is it located in Mamba? Or is it located, I think he forgot one area, which is called CAV, and some of our colleagues here know the big history of CAV, of the auditorium. Yeah, so the Vice Chancellor was not there when this was raised by our colleague, Dr. Elvis. And he raised also this, he projected this picture on the screen. If you can look at it, Honorable Vice Chancellor and others. So he was wondering, he actually was mentioning that everyone comes from a home. So anyone here, participant here in this room, belongs to a given home. So, and he was wondering whether if you go back to your home to see your mother or your father or your brothers, would you go with these fancy cars and be parking surrounding this almost beautiful house? Yeah, so, and now I will come back to some of the historical discussions that we have had, and I'm happy that Maitre Emmanuel Butare is here. I will remind some of the participants here who have been here in other discussions before that in 2018 we had a very good discussion in which we agreed with the participants that there was a need to have a home where you would love to bring your children to show where you come from, and where you would want to bring a visitor to show your home. And at that particular point, we even reached the point where some of the participants volunteered to to contribute to the building of a home of the School of Law. So I didn't go to the whole history of the School of Law, where it was born, and where it is now, and where it should be. This is not the point of the discussion, but the question is, where are we? Where is our home accessible? Do we have a home that is accessible, from which we would expect to have products that we want? That is the question that is put to you. And we are glad to have also Dr. Prosper Simbarashe. I think I have to mention this name. He's originally from Zimbabwe, and his name is Prosper Maguchu Simbarashe. So he probably could also share some experiences with the other places. But the question, I suppose you have gotten the question. So I think you will have 5 minutes each, and I will start with the Honorable Chief Justice. Thank you.
Yeah, thank you, moderator. I was just thinking that the Vice Chancellor would be privileged to start because we had the opportunity to talk before. But when I am talking, I'm seeing the theme of this panel, or the panel, the theme we have to deal with, the visibility of School of Law in terms of infrastructure. I'm not thinking about only what we can call physical infrastructure. I am most thinking about challenges related to, setting up a strong legal education. That is in terms of maybe the soft infrastructure rather than the physical infrastructure. I don't want to minimize the physical aspect in terms of location. But what is more important as far as challenges in legal education is concerned is to have the requisite tools in order to provide an effective legal education. In terms of the human resources that are available. But before the human resources, you have to have a strong, as we have highlighted before, you have to have a strong legal curriculum that is well designed to fit the purpose. And then, of course, you have to have, as I said, the human capital in order to carry out or to teach this legal curriculum. Of course, when it comes to go through the legal curriculum that we have to teach, there are some aspects that you have to take into consideration. Not only the theoretical aspect of the teaching, but also the practical aspect of the teaching. When it comes to the theory and the theoretical aspect, of course, you have to have people with strong research skills that can level up the level of legal education that you are providing. But it has to be also in a setting that is also facilitating the practical aspect of it. What I mean by that? I mean that people would have the theoretical skills, but they have also to be challenged by the practical aspect, moot courts, internship, this research aspect, and it has to be there. And that is where some institutions like the judiciary have, as the Dr. Oster said, has to partner with the institution in order to give the opportunity for the law students to be exposed to the workplace. And that is where we are coming in as the judiciary, as other institutions in the legal sector, being the prosecution, being other sector that can offer internship, so that those people are exposed really to the workplace. I might go along, with other aspects, but to sum up, there is also another aspect that can encompass what I have said. It is to set up a kind of institutional framework to oversee the implementation of any education system that we have set up. I was complaining, and people were saying, yo, you have not to complain. You have, to act, to take action, concrete action. So I was complaining that we have some problem with carrying out an efficient legal education. But what I have in mind as far as institutional framework is concerned is to have what other countries have as a legal education council. That will oversee the legal education in all institutions that are providing this kind of education. So it has not to be left to a kind of vacuum. We have to have quality control of the education system that is provided by those different institutions. Let me stop here.
You have the floor, Honorable Vice Chancellor.
Thank you, moderator. Honorable Chief Justice, distinguished participants, all protocols observed, good evening. I am very happy to be with all of you in this room, thanks to the effort of the College of Arts and Social Sciences, in particular the School of Law. And I would like also to thank all of you who are participating physically and virtually in this event, where we're discussing about legal education in Rwanda, for Rwandans, for East Africa, and for the continent. I would like first to ask two simple questions to all of us, given our commitment to be part of legal education at University of Rwanda and other higher learning institutions in Rwanda. And my two questions are simple. The first one is, as of today, if an ordinary citizen goes to court, is he confident or is she confident that he or she is going to get fair trial? My second question is about, to what extent exposing lawyers to quantitative methods would contribute to enhance quality of research and innovation in the legal field? I don't have responses, but I leave the question to all of us. Be presumed innocent until proved guilty. How our graduates contribute to make this a reality. We've got also a presentation by one of recent PhD graduates about right to reparation. How in our judiciary system, whenever we share between generations to inform working relationships and also kind of preparing the young ones to come in when time comes. The third is about establishment of a collaborative framework. We've been saying, let's partner. But I'm fortunate that I am with the people who are used to draft laws, legal frameworks. So can we have a kind of instrument that could inform and help us have a kind of framework of collaboration between University of Rwanda, public institutions, and private institutions that are involved in legal education or that are heavily interested in legal education? Lastly, moderator, I wouldn't like to be too long, but I would like to come to now the physical infrastructure. Yes, I have seen nice cars surrounding a nice house, but I'm sure that the father who lives in that house would like to give same comfort to all his children. That is the reason why University of Rwanda, that I am representing in this room today, we are really, yes, looking at how best we can improve on infrastructures for our students to learn in acceptable conditions. The first infrastructures would go for accommodation of our students. We would like students to live well. We would like to improve the quality of hostels where students learn from. And that is core. The second one, it is the classrooms and teaching halls. And for this, we are having different partners who are coming to us, we are partnering with. And whenever possible, we will be more than happy also to partner with you so that we could see how best we could inform the two physical infrastructures, hostels for students in law school, and also teaching halls for students. But infrastructure nowadays is not about buildings. The students in the first year of law, I was even this afternoon trying to discuss with the Minister of Education, do not have ICT tools to learn in a blended mode we are we have embraced as University of Rwanda. How best can the community of lawyers partner with the School of Law and facilitate students in the school access those needed and essential tools, means either laptop or tablets? Today, we are creating a divide between children coming from wealthy families and children coming from families that cannot afford a laptop, because when they live with $1 per day, it translates into $365 a year. It is less than the price of a laptop. So ICT infrastructures, ICT equipment, it is no more a luxury, it is a necessity. How can we work together to make sure that our students, all of them, can have a conducive environment for learning using ICT tools and technologies? Lastly, I would like also to say that I was contacted by the school and University of Rwanda is ready and willing to provide plots for the construction of the School of Law. And I would like to thank the team that has been working on that project. So I thank you and would like to assure you that University of Rwanda is more than willing to support this initiative, and if necessary, we can put £1 of University of Rwanda to £1 contributed by Alumni Association. I thank you.
Thank you very much, VC. I will now give the floor to Maître Butare Emmanuel.
Thank you very much, moderator. My Lord Chief Justice, Honorable Vice Chancellor, Chief Justices present, mon bâtonnier, colleagues, distinguished participants. The topic that we are trying to discuss now, it's a bit late, but I just want to basically anchor what the Chief Justice mentioned, even the Honorable Vice Chancellor. The visibility of the School of Law is not about the physical infrastructure. It goes definitely with quality products that come from the university, from the school. And I think we had a panel here that discussed rethinking on how the alumni can actually help in terms of having collective education. I'll for sure not go back into the importance of having good products from the School of Law. I think that has been discussed, and as practitioners, we also interact or interview or recruit some of the young or fresh graduates. And in most cases, you find that there is need of a lot, there is a need, and much effort is needed to ensure that really the level of education that you get from those interviews, it needs really to be revisited. However, I'll want to go on the other side and start with what the Honorable Vice Chancellor has just ended with. And it goes with basically asking a question, in a few minutes, I think we will launch the School of Law Alumni. And I think what is important for us by having that launch is, what are we going to do to the School of Law as members of the alumni? I think that is what is important. Now, that goes with what has been discussed before in terms of helping the students in mentorship, internship, in training, in all that. And putting in the structures. But I think it is also very important that the environment in which these students are getting this education is also looked into. I think those posh cars you saw surrounding that house, if that house was different from the way it is being seen, I think everybody would be very happy. And that goes with the question that was asked in the morning, whether any of us knows the location of the School of Law today. So I want to say that, given that the university administration is ready to offer where we can put that infrastructure, I think that is something that we can look into as the alumni and see what we can do to actually help the university. Because the university is not looking at the School of Law only. It is looking at the university, and it is looking at all the other faculties, which makes sense. But as alumni, people who have been nurtured or have been born by the school, I think if we put our hand and we help the university administration to at least do that among the so many projects the university has, if we can say we are going to help you with the project of working on where the School of Law should be, I think that would be a contribution from this alumni that will really be very, very, very useful. And what does that require? I think there is what has been mentioned as needed to partner. But I think, again, having a partnership, you need to have a binding partnership where decisions are taken, resolutions are adopted, and they must be implemented. And there is a way you can actually follow the implementation and confirm that what is supposed to be done is being done. That requires ownership. Now, as alumni, if we are agreeing based on what the Honorable Vice Chancellor has actually offered us, then we must have ownership. I know everybody would be extremely happy and proud if there was a very good structure called the School of Law in a place that is very convenient and accessible to actually go and offer any kind of service in that school. This does not mean that it is a problem for people to drive to campus in Huye. But I think if there is a possibility to have it nearer, where most of the practitioners are, where most of the institutions in the justice sector are, then that becomes easy in terms of getting good services or good practitioners that are going to save some of their time and actually come to give a hand. So without taking much of your time, I'll just urge each one of us in a few minutes we'll launch the alumni, and we are so happy that the Lord Chief Justice accepted to be the chairperson. And that itself, for me, is something that is very important, and it is a very good way forward to ensure that we actually now have an alumni that is existing and that can actually do what we are going to agree on to do here in terms of participating to help the university have a structure for the school. And probably the organizers will help us to know now going forward what is required in terms of putting a structure, whether it has to be a committee or whether it has to be the way they want it, so that now we agree. If you looked at the numbers of people who have gone through the then Faculté du Droit, which is the School of Law today, if you looked at the numbers and you just go in a few calculations, I can tell you that the structure we are talking about, we can have it as soon as you commit and own that project. So I want to thank each one of you, and I want to believe that the sentiments I have to have good infrastructure in terms of physical infrastructure, that it definitely has to go with the kind of quality we are going to have or to give to the kind of products, the quality products that we need from that school, that together we can actually have this done. And the good thing is we have the hand of the university senior administration to help us through. So I want to thank you, and I hope we are together in this journey. Thank you very much.
Thank you so very much, Maitre Butare. Now the floor is for Dr. Simbarashe.
Thank you so much, moderator, for using my African name. And also thank you, Chair, Honorable Chief Justice, Honorable Vice Chancellor, distinguished guests and participants, all protocols observed. I'm thrilled to be part of today's conversation. And in particular, I'm thrilled to see that the idea of an alumni, a journey, so to speak, that we started together with our colleagues from the School of Law is just a few minutes away from seeing the light of the day. Despite drawn curtains, maybe we need to open them at the right time, but that's a joke. All right, so within the next 5 minutes, if I still have 5 minutes, I'm going to speak just briefly on harnessing the alumni network. This is nothing new. There's nothing new under the sun after all, but there's nothing new that I'm going to say today that I haven't already shared with my colleagues here. So just allow me again. I'm in academia and I suffer from that disease of academia. Wherever we find ourselves in a discourse of some sort, we always want to start with a disclaimer, a caveat, and just allow me to give one caveat. I'm no expert in setting alumni. So I'm going to offer my opinion with much hesitation. This cannot be classified as knowledge, but it's based on my experience, my little experience in higher education. So now just allow me to start by, I've prepared a couple of slides, but I think in the interest of time, it will be difficult. It will be too time consuming to show them. But let me start with what I always do. Friday's useless facts. Every time when I'm teaching on a Friday, I start by giving this little trivia. So today, what would otherwise be a Friday's useless fact may actually be very relevant I have a question for everyone in the room. How much do you think is the most amount that has been donated to a university by an alumnus? Who wants to take a wild guess? In the history of donations by alumnus. Okay, it might take us the whole day. Michael Bloomberg has donated $1.8 billion to his alma mater, Johns Hopkins University. Of course, I'm not challenging colleagues here that you should donate 1.8 billion, whether in francs or in US dollar or any other currency. But what I'm going to say is that it is important that we harness the alumni network that we are going to create today. And I have a few points that I want to share with you. So the first one is that you need to invest in your alumni. So it's not just one-way street. You also need to invest in your alumni. Keep them updated. Give them something. Offer them an incentive, what I call the drug dealers syndrome. You know, you give a little bit of drugs, get them hooked, then they will come back to you for more. So try to do something that will also make the alumni to feel to feel as part and parcel of the university initiatives. The second point that I have is you should also ask for feedback. So this is your constituents. This is the most important part. So ask always for and take feedback, even unsolicited feedback from the alumni constructively, in order to help build this young alumni that is going to be launched within a few minutes. I'll just rush through the points that I've already prepared. And also very key is that you should reduce the direct financial requests. Dennis, the dean. So most of your emails to the alumni should not just be about finances. Try also to see if you can benefit in many other ways. We are talking about visibility and building of infrastructure. Which other ways can you also benefit from your alumni without just directly asking for funding? Those emails can be very annoying. So try in a way to also engage your alumni in many other ways. And I'll finish by answering the question. So the guiding question is that, whose responsibility is it? Seems like a rhetorical question, but quite important. So the responsibility, of course, will still lie with the university. Yeah? So this brings me to the fifth point, is that when you assign a budget, please assign a reasonable budget to the alumni. Right? Do not expect them to carry the lion's share of your budget, whereas you carry the baboon's share, and hope that all will be well with them. So I'll close, allow me to just close on this statement. And of course, thank you on behalf of my colleagues at Freie University at Amsterdam. We'd like to thank you so much. And I also want to thank you, colleagues, for your attentive listening. Thank you, moderator.
Thank you so much, Prosper. Okay. Yeah, I think as we have done for the previous panel, I will give the chance also to the panelists to comment, if there is any comment to what others have done and have said, to react on anything that has been mentioned by the other panelists.
Thank you, moderator. I just want to say that, of course, I started with a disclaimer. I am not as the senior counsel, Utare said that I am the would-be chair of the School of Law, Alumni Association. No, we have not yet designed any or voted any chair of the alumni, the School of Law Alumni Association chapter, because it will be a chapter of the UR Alumni Association, for which I am the chair. That is the one for which I am the chair. But for the School of Law, I am not. And I hope that during this evening, we'll be able to have a committee, because we have not to depart from here without having the committee for the School of Law Alumni Association chapter. So otherwise, we have been talking about legal education. We have shared some thoughts. Let us go to the implementation stage. And with the aim of really improving legal education. And from my perspective, where I see the gap is to set up a supervisory and institutional body in order to oversee, this implementation of any legal education system. Without that, we will be having proliferation of legal school from one university to another university without any collaboration. We have to start from the beginning, and we have not reinvented the wheel because we have some well-experienced other sister institutions, the ones that are partnering with us, for example, from the Netherlands, or other from South Africa, as some people were referring to USCT or other institutions. So where I see the gap is on the institutional level. Let us set up really an institution, a supervisory body in order to oversee any legal education system in this country. Thank you.
Thank you, Chief Justice.
Honorable Chief Justice, distinguished participants, once again, my simple words are to thank you very much for taking your time to think about legal education in Rwanda, to be ready to contribute both to inform quality education, quality research and innovation in the legal systems. And also, I would like to say that, as mentioned by the last panelist, but not the least, university assumes its responsibility to provide proper working environment to all our students, including students of the School of Law, but not only students, but also academic and support staff or administrative staff. So we'll continue doing our best, and we thank you very much for considering being part of that journey. Thank you very much.
Thank you, Vice Chancellor.
Thank you, moderator. Lord Chief Justice, I think when I saw your name here I just immediately thought you were going, it was a wishful thinking. So, but in any case, if the committee is going to be elected, then either way, we are very honored that that you were part of us. What I want to say is that, as the Lord Chief Justice has just mentioned, I think by the time we leave this room, we will have agreed on a roadmap of exactly what we are going to do as alumni to answer who is responsible. Basically, it is us. So I think by the time we walk out of this room, we'll have agreed on a roadmap. And I'm very optimistic that by the time the organizers call for another meeting of this nature, then we should be able to be presenting something tangible to the members. Thank you very much.
Thank you very much. Doctor?
Oh, yes. So the Honorable Chief Minister of Justice made an analogy that you need to water the garden. And I must add that we also need to invest in cultivating the alumni network that is going to be launched today. Thank you.
Thank you so much. I think I will not pretend to summarize fully these brilliant ideas from these eminent panelists, but I will try to mention a few of the points that I've been able to capture. I like the point that they are all in agreement that infrastructure we are talking about is not only about the physical infrastructure, but it includes also other soft infrastructures. And this is indeed a fact. But I also like the point that they all agree that there is a need indeed of the physical infrastructure to allow to enable the school to operate as efficiently as it should. And I also like this concrete point mentioned by the Vice Chancellor that the university is ready to help with, by all means, but also with some concrete already point that he mentioned that the university has offered a plot where the School of Law could be constructed, and that the university would be supporting any initiative by whoever would be willing to support. And this idea of networking that was mentioned by both Emmanuel and Prosper is also very important. But I would want to maybe conclude by something that was mentioned that might lead to something concrete. There is what Council Emmanuel said that there is a need of a framework of this partnership, but he also wondered what would be the form of that partnership and how binding would that be. And he was wondering also what is required, what can be, what is the thing that would say that we take as a take home from here, from this discussion, where in relation to the way forward. So I think he was leading to maybe suggesting that there be something like a team or that would look into the project in a clear way. And this, I think, I heard also others clapping, and from that I suppose that they also love the idea. That is why I will thank him and others who have contributed to this panel. But I would also conclude by saying that it is very important to have a working environment for the School of Law if we want to have the product that we want. But for some other concrete actions, I will leave to my colleague, Dr. Elvis, to see what could be next in terms of what has been suggested here. And doing that, I would invite the panelists to remain here while for me, I'll be going back. So my colleague will take the floor.
Please give a round of applause to the moderator and the panel. Thank you very much. I'm very happy with what we have gotten so far, and especially this panel about our school. The question asked about whether it is just about the infrastructure that we can see, but we all found clearly that actually the speakers expanded the horizons and they talked about many other aspects, more specifically what is related to the legal education, the substance itself. So if we look at our time, I think we are already like 15 minutes or 10 minutes, 20 minutes late to the agreed time to finish. So for that reason, I think, and I'm suggesting here that instead of taking questions from the room, we'll take questions from people who are online, because we have some participants who have been there since we started. So we'll get questions from those who are online. And for us who are here, we can still ask our questions during the cocktail, because I hope that everyone will be here. So that may help us save some time. So do we have any question online? Yes. No, I'm not yet releasing you. Sorry. I will release you. Actually, Honorable Chief Justice still have a function.
Just we can regain our seat.
Okay, if you so wish, but I would have.
That is you.
All right, thank you very much. So I'll keep you there for some other minutes. Good. So we have one question online, and that question is asked by Rodrigue. We wish to hear from the panel, the panelists, what they think the School of Law should have its own library. Do you think that the School of Law should have its own library? And I think this actually applies to the last panel, and this is even one reason why we should just keep the panel seated. Do you think there's a need for a special library for the School of Law? I will give each panel, starting from Honorable Chief Justice, 30 seconds to respond to this.
No, it depends to the kind of library you are talking about, because it is a physical library, but now we are talking more and more about e-library. So let us have both. And as far as they will have enough material, e-materials, but also the physical material, that is the requisite tools. So how can you operate without having the requisite tools in order to operate efficiently? So it is obvious.
Okay, Honorable Vice Chancellor, do you think that we need a special library for the School of Law?
Thank you very much. Library means first a physical location, but also it means different items, books and e-books and so on. In my view, what is important is to make sure that we have comprehensive resources for students to learn. It could be in the library of the College of Arts and Social Sciences, but what is critical is to make sure that what is needed for students and academic staff to teach and others to learn is available. And I fully agree that it is the minimum input we have to make sure that it is available.
Thank you very much. Senior Counsel Emmanuel, do you want to add something?
Thank you very much. I totally agree with what has been said.
Perfect. Prosper, would you probably share with us what is the situation in Amsterdam?
At FU, it's quite a complicated situation in terms of the issue of space. So actually, some of our books now are actually hidden. You just have to click somewhere where they can be retrieved. Having said that, a library is quite important. As a lawyer, you win or lose your case in the library. Elsewhere, where space permits, it would be ideal for a law school to have its own separate library.
All right, thank you very much. I hope that Rodrigue got responses to the question. If he had in mind the question of a library as a physical building, I think Chief Justice has extended, saying that it's not just about having a library where you have physical books, but we should also think about online resources. And when it comes to online resources, I think that having the books of law separated from others does not really make relevance, because everything can be obtained from just searching through different library tools. Is there any other question online? No question. All right. Thank you very much. So I will request the panel to remain seated as they are, because I don't want them to leave Chief Justice alone, because he still has a function to take. So our next item is the launch of the UR Alumni Association School of Law chapter. I'm sure that we have all understood from the clarification made by Honorable Chief Justice that we have already at UR a alumni association of which Honorable Chief Justice is the head. So here we are talking about the School of Law chapter. And from the information we have collected so far, we have already received 350 names of former School of Law students, the one we call alumni, who have expressed their consent to be part of the Alumni Association. Of course, this is not very big. Of course, give a clap. Yes. So we should be very happy of this because the initiative has just started. Of course, if we compare with the whole number of people who have gone through the School of Law, it is still very insignificant. But as a starting point, I think it is very important. So the idea now was to launch the alumni, the chapter of the law school. And we had, with the organizers, a lot of activities that we had planned, but we cannot go through them now. To save time, we tried to ask, but before even we ask, I don't know, Senior Counsel Emmanuel was not with us when we were doing these kind of informal inquiries on what could be the format of the starting board of the School of Law chapter of Alumni Association. And there were suggestions and names were coming back. And I would say that luckily, the name of the Honorable Chief Justice was actually coming up as the person who could take the lead, at least for the starting, awaiting for the real committee to be set up. So I don't have power to silence what others have expressed. So I said, let's bring it open. If there's someone in the room objecting to that suggestion, he could say, but also in the end, Chief Justice himself would also have a say on this. That is a suggestion, meaning that we are having that committee for now until the organization of the election, and we establish our own board that will govern our alumni chapter. In the room, is there anyone who objects to the Vox Populi?
No, I am the one who is objecting. You know, it is like having many children and willing to make some privilege for one child. It is not possible for me, in my capacity, to be the chair of the alumni, the School of Law alumni, chair. It is not possible. Maybe if I am the chair of the whole alumni association of the university, I went into this position when I was not yet in this position of Chief Justice. And some people might see a conflict of interest also. What if someone is saying, as a Chief Justice, when there is some privilege that is given to graduates from the UR rather than other from other university, School of Law, you see, it is something that I have to discuss yet with the Honorable, the Vice Chancellor of the university. But for this specific chapter, let us really be realistic. Let us be realistic. I will be, of course, closely and following the activities of the chapter. What another setting I can be a patron. That is maybe the position that can be envisaged, but I can't be the chair of the chapter as far as the School of Law Alumni Association is concerned.
Valid point. I really feel like it is totally valid, but it was my obligation just to voice what others were suggesting. So I could see the Dr. Didas.
Thank you so much. Mine is just to propose a candidate that would really help us to form a founding team of dedicated lawyers, those who are going to be steering the progress. And for sure, even the campaigns are over. He has done great, and I'm sorry, the candidate has done everything, including the presentation of what is thought about in order to have, a clear way forward. And I offer Councillor Emmanuel Butare to lead us for the. I'm requesting Council, given that he has already campaigned, he gave us what he thinks can be done. Who else is going to start thinking about what to bring on the table when we already have someone? Thank you so much, Council, for accepting. Thank you.
Thank you very much, Rector. We have seen the acclamation, and the sound of the acclamation simply means that this should not be declined, unless you have also some very good point. But I think we, as the Assembly, can also assess and see if it's something we can agree with. Thank you very much. Thank you. So actually, he was also among the people that were coming up after Chief Justice. So what you have said did us just meet already what we're having in the polls. Okay, now, a good idea. Let's just make it a committee of 3 people. We have had Councillor Emmanuel. Of course, the Dean of the School of Law should be part of it. Now we need a lady who will be the member to second Councillor Emmanuel. A lady from the audience.
I can see several capable ladies, and I cannot suggest all of them, but I will just use one criteria of one who is facing me, and this is Specios Kabibi.
Okay, so we have Councillor Emmanuel, we have Ms. Specios Kabibi, and the Dean of the School for the time being. So this will be the team of people who will set up the elections, if need be, so that we can start running our... Okay, there's an objection or an addition? It's democracy.
I come from a history of this school of law, and I don't want to be historically poisonous, but that whole track is an Anglophone track. And we had a bigger group, and we have had people as part of those classes. So I don't want to sound discriminative, but I want to propose a lady who came from the bigger other side of the track, because that's really connecting to the people you know. And I do not have another candidate other than the deputy. There's no conflict of interest, is there? The deputy SG of RIB. Thank
Great.
you very much. Thank you very much for accepting. I am in charge of governance, so I speak about everything, including inclusion. Sorry for that.
Okay, so I hope the note takers are doing both of them. Okay, so that makes 5. Great. We take Eusta and the deputy, hey, not Eusta, Kabibi. Kabibi, I mean. But the assembly has consented for you. Exactly. Expanded. Yeah. All right. Okay, do we agree, members? We still have the vice chancellor who has a word.
Is it a practice in a lawyers gathering not to give room for people nominated to express their consent?
Actually, the practice is that if someone has a consent, this consent, they would express it as Chief Justice did. So those who are not expressing any kind of lack of consent, we assume that they have consented. Agreed, members? All right. Ladies and gentlemen, distinguished guests, it's really a pleasure to land this workshop, and I would like, allow me to welcome Honorable Please allow me to welcome Honorable Chief Justice to officially close this interface workshop, but also at the same time officially launch the alumni chapter of the School of Law, University of Rwanda. Please, with your applause.
Thank you very much, distinguished participants. Mine is a thank you. Thank you for this afternoon that we have spent discussing, exchanging views, elaborating on how really to set up a strong legal education or a legal education system in this country. So I'm sure that as from the judiciary perspective, we are very glad that we are discussing this topic because we are talking about the quality of product that we'll be using in our respective institutions that are using legal professionals. I am very glad that also other sister institutions that are represented here from the Netherlands or from other countries have gladly accepted to share their experience, and we are very, very grateful for your experience, but also for the continuous support for your continuous support to the to strengthening legal education in this country. So as we have been talking about it, let us move to the practical aspect of it. We've been talking about the lack of or some deficiencies and loophole or some gaps in our legal education system. We have formulated some ideas and orientation. So I think that the organizer of this workshop, I'm sure that it will, be highlighted in the report what would be the recommendations of this workshop as far as strengthening legal education is concerned. I was sounding the kind of alarm bell, but I am sure that it is my responsibility to do so because the next generation of lawyers is being educated now.
So if we are not really doing enough in order to have the good product as far as legal professional is concerned, we will, of course, be failing this country in terms of looking ahead. So I am confident that we will be able to implement the recommendation that we have been formulating here, and that next year, as some panelists were referring to, we'll be able really to see some tangible results. With regard to the chapter, to the University of Rwanda School of Law Alumni Association, the chapter that we have just launched, it is really a pleasure to see that this chapter is coming, and it is the second one because in 2019, I think 19 or 20, yes, 19, because after we were not able to meet. At that time, we launched another chapter, the first chapter of medical professionals. So we had a second chapter that has been set up now. And as Senior Counsel Butare said, and I'm happy that he's now chairing the committee that we have set up in order to materialize really the setting up of this chapter. As he said, we can really see how, in a practical way, we can contribute to the, being the infrastructure, physical or soft infrastructure that we have been talking about as far as the School of Law is concerned. It is possible. We are now somehow a number of 350 people. I am sure that we'll be increasing the number of alumni, and if he was making some small calculation, I'm sure that we can make our contribution. We are not saying that we'll be the one that will be built. Let us be realistic. We will contribute, I am sure. We'll contribute, and the tangible contribution to the setting up of this structure. But of course, we'll be looking to other contributions, and we are very happy that the leadership of the university has already agreed to avail, a plot. But let us really work hand in hand in order to materialize this project of having a physical location of the School of Law. So on this, thank you very much, everyone, for your contribution, for the fruitful exchange that we had this evening. Looking forward really to continuous, strengthening of the legal education. In order to answer the question that the Honorable the Vice Chancellor, asked in his when he was giving his remarks, of course, we have many gaps as far as justice dispensation is concerned. There are many concerns with legal professionals, and it is our responsibility really to see how we can tackle problems that are there in order to provide and to deliver fair justice to the Rwandan citizen or to all people living in this country. So we know that we have some gaps. We have many challenges, but we know that people will be trusting us as far as we are competent, and as far as we are behaving in an ethical and a professional manner. The challenges that we have, as Justice Karimunda put out, are related to competence and ethical and professional ethics. So we have to work on it, on the competence that we have to level up the quality of the product that we are having from our School of Law in terms of the competence, the professionalism, but also in terms of the ethical character, because it is going hand in hand. So thank you very much.
and looking forward to a continuous exchange and engagement in order to implement our recommendation. Thank you very much.
Good. The session has been closed and the Alumni Association launched. I have nothing else to add. Mine now is just a matter of announcement. To be part of this, as a sign of remembrance, the School of Law and ILPD made actually T-shirts for everyone. So it will be also a good thing for each of you here to pick up a T-shirt at the back as a symbol that you were there when this Alumni Association, the chapter of the School of Law, was launched. The second announcement is that when you look at the back, we have cocktail, which is already staged. So